Supplementary list item number 1.
May I please, Judge? This is a case where the father has, before the habeas corpus before this honorable court in year 2013. Initially, this honorable court showing some displeasure over the investigating agency, that is the police officials. And thereafter, this case has been handed over to the crime branch. Your Lordship may kindly see the last order passed by this honorable. Even though I have supplied in every aspect, every corner of the case to the State Council, but till today.
Which order you are referring to?
Last order passed by my Lord Justice Talpatra and
12 September 2022.
my Lord. This
What is your prayer in this writ petition?
for production of the kidnapping of my son.
Who has kidnapped?
That the person I have annexed that FIR, my Lord. 8 number accuser there. Page 7 of my brief.
Yes. So what is the result of this case investigation?
Till today, that has been continued.
Yes, Mrs.
My Lord, last instruction we had received was filed an affidavit on behalf of the SP-CID crime branch on 10/8/2022. That was the last instruction we had taken. Your Lordship.
The matter was last listed on 11/8/2022.
My Lord.
Yes.
Order number 35.
Have you got the case diary of that Rajnagar PS case number?
Rajgangpur.
Rajgangpur, right? 232 of...
CD we have not received, if you Lordship. CD, we don't have the case diary, have not received.
No, whether the investigation has been closed or it is still pending.
Well, that instruction I have to take. Your Lordship is granted shorted because the last affidavit we had filed that we had your Lordship will see this and
that is quoted perhaps.
Yes, that is there.
What has been mentioned there?
The last line is that till date no clue has been obtained. The present whereabouts of the missing person, how the case is under investigation. This is the last instruction we received. I would pray your Lordship may grant a short date because this is almost.
The case is.
Yes, I know, my Lord. I'm conscious of that.
FIR is dated 9/12/2012. So, whether your investigation is still on. And
on. My Lord, if Lordship will say this, Amaro Thilate, this is a case of voluntarily hiding or he has, because the case was pending against him by his wife in Chaimbasa. We have also taken that averment in our affidavit.
What is the age of the person who has been kidnapped or abducted?
Around
43 years at the relevant time, that is in the year 2012.
On what basis you say that is it your just apprehension or anything you just...
No, there is a material, sufficient material, my lord.
What material?
Material, my lord. On the relevant day, I had been to Rajgangpur to see my kids. I had been to the school. The headmaster interacted with me.
Who had gone to the school?
The Dharmendra Kumar Karesia, who has been kidnapped, my lord.
Okay.
He has boarded in a hotel, my lord. He has withdrawn some money. CCTV is there, my lord. On that occasion, my lord, from that place, whereabout is not known, my lord. Even though I have interacted with my advocate.
No, it's all right. So that means he is missing.
Missing, my lord.
So if he's missing, then how habeas corpus will lie?
Why, my lord, I am saying so? This is a case of 363/506 along with the other.
No, you have your suspicion in the FIR that these persons might have kidnapped or abducted your...
My lord.
So, but there is no basis of that.
My lord, to that extent, my lord, I am submitting.
It is your suspicion or not? Or you have got any concrete proof? Have you seen?
No, because
any witness has seen that they were taking this man.
No, this is
then
the duty of the
how
my lord,
on
to
your
that extent, my lord,
on your suspicion, why the against missing person to trace out that missing person. Why this will entertain this
Writ
of
application is
habeas?
maintainable, my lord. To that extent, this honorable court,
Then every kidnap case
Every-
will end up in habeas corpus.
your lordship might have come across judgment of the apex court.
every missing person's case would be entertained in a habeas corpus writ petition
My lord,
without any averment that he has been illegally detained or wrongfully
no,
confined.
my lord, my anxious before your lordship.
Your anxiety is something different.
Even
We are
accepting
concerned,
for a
we
moment,
are
my lord,
concerned with the maintainability of a
that
habeas
case
corpus
is
writ
maintainable,
petition.
my lord. That is the apex court judgment, my lord. First occasion I have cited that judgment, my lord. Only 363 on suspicions, habeas corpus is maintainable.
There are law has been changed in the meantime. What
My
I will
lord,
tell you.
even by accepting for a moment,
2019,
kidnapped,
2022 judgments are there.
my lord, because even though accepting for a moment, your lordship is saying so that 22 judgment is there. Previously, my lord, that 22 judgment has not been taken care of the previous judgment. This is a case
Everything
of
has
foreign
been
crime.
taken
That is
care of
otherwise, my
in
lord.
the 2019 judgment, and yes, since this case has suffered so many adjournments,
My lord,
My
we
lord,
just
adjournment, every occasion we have filed some other the status report saying that, my lord, it seems that he, in order to avoid the legal complications in a 498 case, he has taken this step. My lord,
It is 5 years.
yes, it's
my
all.
lord, I am submitting
Yes,
before
sir.
your lordship.
He has changed the LIC
My-
nominee
my-
from his wife to his mother. In the meantime,
have you got any material so far on record that his suspicion has any basis or any material against these called persons who have been named as an accused?
no, my lord, not yet.
Then,
Because we polygraphic test of his relatives have been done also. Nothing has come out. Nothing fruitful has come out. In the meantime, the case has also ended in
all right,
acquittal.
we are keeping this case for the last time on 25th. You obtain your latest development. We will
Like-
close the case on that day.
25th.
Can I submit before your lordship? 1 second, my lord.
All right,
But
we are taking up this case on 25th. We'll pass the final
They
order.
have confessed before the Kagatnagar, Andhra Pradesh. They have stated so that
See that what investigation has been. You produce your up-to-date case diary
Yes.
and what Lekhan. Though this writ petition in the nature of habeas corpus has been filed with a prayer for a direction to the opposite parties number 1 to 4 to produce the son of the petitioner, Dharmendra Kumar Karesia, before this court, inter alia with other prayers. And it seems that a first information report was lodged by who has lodged this FIR?
my father, my lord. My lord, sister, Sudha Vyas. Page number 7 of my brief.
How he is related to this petitioner?
Sister of the
Sister of the?
Dharmendra Kumar Karesia.
That means Bikram Chandra Karesia, who is the
father of the
okay, that means daughter of the petitioner, right? Daughter of the petitioner, Sudha Vyas, before the inspector in charge of Rajgangpur police station against some persons for which Rajgangpur PS case number 232 dated 9/12/2022 has been registered under section 363 506 by 34 of the Indian Penal Code. The learned counsel for the state, Mrs. Patnaik, submits that she has instruction that the investigation is still on and nothing has been found so far that the son of the petitioner has been abducted, who is aged about like them,
43 years.
43
at the
years,
relevant time.
at the relevant point of time, have been abducted by anybody. And no material has so far found against any of the accused persons named in the FIR. Since this matter was listed for the last time on 11/8/2022, and in the meantime a year has passed, we direct the Learning State Council to take up-to-date instruction about the status of Rajgangpur PS case number 232 dated 9/12/2022,
2012.
9/12/2012,
12.
and a specific instruction as to whether the whereabouts of the son of the petitioner was found, and whether any material was found that any of the person is involved, whether he has been, any material was found that he has been kidnapped, abducted or not, and if so, whether any material has been found against any accused persons. Free copy of the order be handed over. List this matter on 25th of September 2023.
22nd?
25th of September 2023. Yes, next.
Can I cite that judgment by file?
File the learned counsel for the
81.
petitioner files the
I-
citation in so and so.
Well,
Since
yes,
prima
yes,
facie case appears to be a missing person, case of missing person,
missing person.
in view of the ratio laid down by the Honorable Supreme Court in case of so and so, the
1981
learned counsel
Supreme
for
Court
the
case 1026.
petitioners are satisfied on the next day about the maintainability of the writ petition. Yes, free copy of the order be handed over. Yes, next.
Add-on 2.
Oblige.
Yes, what is this, Mrs. Patnaik?
No copy for my lord.
Huh?
Copy not received, my lord.
To allow the, what is the prayer? Was the order dated so and so?
Maintenance.
Nitish Patnaik. WP 21/5. What is that order? Petition has filed so and so. Interim maintenance and litigation expenses. Okay. What order has been passed? To pay sum of rupees 5,000 towards interim maintenance per month from the date of application. It party so and so. So why this WPCRL
Exactly.
has been filed?
It
It was earlier filed, I think revision was filed. Then there was some kind of order has been passed for us, for which notice was issued. WPCRL. Okay, it is perhaps the registry pointed out. Nomenclature is not correct. Correct nomenclature is WPCRL. Okay. It is actually held in a three-judge bench decision of this case that against final order revision would be maintainable against the order of the family court, and criminal appeal would lie in some cases, but maintenance, so far as maintenance is concerned, revision would be maintainable.
This is a case
But-
of 2013, my lord.
Interim order is concerned, that is the maintainability would be a writ petition. The three-judge bench decision, that is perhaps sometimes in 98 or 99. So then earlier that was WPC were filed. Then the nomenclature changed to know this type of matter, it has to be WPCRL. So that is how it is. Are you having that OLR? OLR of 1999 and 98, 99 देला देखिए edition टा इससे हाँ Justice P.K. Tripathi, Justice three judge bench decision was page 1 Raj OLR ଅଛି ତ give କୋଉଟା ଆଣିଲ? ଅଛି ତା ଦେହରେ ଦିଅନ୍ତୁ। Right. No, this is Orissa cell tax. What are you? Bring out 1999-98 ভলিউম, প্রত্যেক বর্ষ দিটা ভলিউম বাহারে। Bring 98 volume 1 and 98 volume 2, then 99 na volume 1 and 99 volume 2 টা দেখি, ফ্যামিলি কোড একটা দেখি।
Family code.
Give those books to me. বহি দিও। See the page 1, is it a 3-judge bench decision? Family court act or nahi? Diyo? Yes, this decision. This is the question put before the full bench decision. Question is whether an order granting interim maintenance pending light is appealable under section 19 of the Family Courts Act 1984. If it is held that appeal is not maintainable, what remedy is available to the aggrieved party? This is the question put before the full bench, and the answer is
Doesn't lie, it's right.
right. That is it. So that
This
is
not the
how
final.
against final order the appeal would lie under 19 against other orders like MATA. But so far as maintenance is concerned, revision would lie, and interim maintenance, this WPC would
Interim
matter.
maintenance is the nature of interim order.
Ah,
The principle is the final order where appeal doesn't lie, revision lies. So therefore, interim order read only can lie.
so
That is how it is.
the person is not there and it's an interim maintenance order. So
This-
why should we keep it pending?
last
Huh?
order also.
मतलब RPFM file होगी?
No, there is no representation since last 2 occasions.
Her
When the order,
husband, her
yes, Mrs. Patnaik, what do you say?
RPFM.
No, RPFM. That is, they have said that it's a different type of order. See, ये जो maintenance ପାଇଁ
Interim
ଆପଣ
Interim order maintenance
interim
course,
against
interim maintenance course.
ଏଠି ଦେଖନ୍ତୁ 19.
Legal maintenance would be a final order.
Final
where
order
revision
of
lies,
appeal.
revision
Revision
lies, or appeal lies, whatever.
See,
Interim
the
maintenance-
intellectual order
19 subsection 4 ରେ ଏଇ type ର କହିଲା ଯଦି High Court 19 ଟା ହଉଛି ଗୋଟେ appeal provision,
ଆଜ୍ଞା।
କିନ୍ତୁ 19 ର subsection 4 it reads like this. It is exclusively for this interim maintenance chapter. High Court may on its own motion or otherwise call for and examine the record of any proceeding in which family court situate within its jurisdiction passed an order under chapter 9, that is maintenance chapter, of the Code of Criminal Procedure Code for the purpose of satisfying itself as to the correctness, legality, propriety of the order not being an interlocutory order as to the regularity of the proceeding. ତେଣୁ ଏଇଟା ହଉଛି ସେ final order ଟାକୁ ସେମାନେ
not being an
interpret କଲେ।
interlocutory.
Interlocutory order ଯେ interim maintenance ଗୁଡାକ ସେଗୁଡାକ revision ଲାୟକ କରିବ କି ରିଟ୍ ଲାୟକ କରିବ ସେଟା।
interim maintenance ଟା ଯୋଉଟା decide କରିଦେଲେ that is also a kind of finality na, that is
ଏଇ decision ଟା 3 judge bench decision କହିଲେ ଯଦି interim maintenance ହେଇଥିବ ତାହେଲେ ରିଟ୍ ଲାୟକ କରିବ, ଯଦି final maintenance order ହେଇଥିବ ସେଟା revision ଲାୟକ କରିବ, RPFM ହବ।
RPFM ଅଛି।
ଅନ୍ୟ କେସ୍ ଗୁଡାକ ଯୋଉଟା ଫ୍ୟାମିଲି କୋର୍ଟ ଅର୍ଡର ପାସ୍ କରୁଛନ୍ତି ଲାଇକ୍ ଡିଭୋର୍ସ କେସ୍ ସେଗୁଡା ତେଣୁ ସେଇଟା ମାଟା ହବ ହେଲା। ସେଇଥିପାଇଁ ସେ ଚାପ୍ଟର ଆମେ ଯୋଉ ଅପିଲ ଫାଇଲ ହଉଛି ଫ୍ୟାମିଲି କୋର୍ଟ ଜଜମେଣ୍ଟ ଏଗେନଷ୍ଟ ରେ ମାଟା ଫାଇଲ ହଉଛି ରାଇଟ୍। ଡିଭୋର୍ସ ହଉ ଆପଣଙ୍କର ରେଷ୍ଟିଟ୍ୟୁସନ ଅଫ କଞ୍ଜୁଗାଲ ରାଇଟ୍ ହଉଛି ବା ଯାହା ହଉ ଏକ୍ସକ୍ଲୁସିଭଲି ଯୋଉଟା 125 କ୍ରିମିନାଲ ସାଇଡ୍ ରେ ଯୋଉଟା 125 ଆପ୍ଲିକେସନ ଡିଲ୍ କରିବାର ପାୱାର ଆଗେ ଥିଲା ମାଜିଷ୍ଟ୍ରେଟ ଗୁଡାକ, ସେଗୁଡାକ ସବୁ ପଳେଇ ଆସିଲା ଯୋଉଠି ଫ୍ୟାମିଲି କୋର୍ଟ ହେଲା ସେଠିକି ପଳେଇ ଆସିଲା। ତେଣୁ ଫ୍ୟାମିଲି କୋର୍ଟ ବର୍ତ୍ତମାନ ଦି ଟାଇପ ର ପ୍ରୋସିଡିଂ ଡିଲ୍ କରୁଛନ୍ତି, ଗୋଟେ ହଉଛି ସିଭିଲ ର କେସ୍ ଗୁଡାକ ଏଇ ଯୋଉଗୁଡାକ ବାକି କ୍ରିମିନାଲ କେସ୍ ଟା ହଉଛି ମାନେ 125 ରାଇଟ୍।
Even DV case ବି ଯୋଉଟା ଫାଇଲ ହଉଛି DV case that interim order will be challenged by
ତେଣୁ ଏଇ ଯୋଉ ଡିସିସନ ଟା କୁହାହେଲା ସେତେବେଳେ 3 judge bench that it would read would lie, ସେ ଆଗେ WPC ଫାଇଲ ହଉଥିଲା ତାପରେ କହିଲେ ନାଇଁ ସେଟାକୁ WPCRL କରିଦବା ପାଇଁ। ସୋ ଦ୍ୟାଟ ଇଜ ହାଉ ସେ ଯୋଉ ଷ୍ଟାମ୍ପ ରିପୋର୍ଟର ଡିଫେକ୍ଟ ପଏଣ୍ଟ ଆଉଟ କଲା ଯେ ଏଗେନଷ୍ଟ ଇଣ୍ଟରିମ୍ ମେଣ୍ଟେନାନ୍ସ ଅର୍ଡର ସିଏ ଫାଇଲ କରିଥିଲେ ରିଭିଜନ, କହିଲେ ନାଇଁ ରିଭିଜନ ମେଣ୍ଟେନେବଲ ହବନି, ଏଟା WPCRL ହବ। ତେଣୁ ତାପରେ ସେଟା କନଭର୍ସନ ହେଇକିନି ସେ ଗଲା ବର୍ତ୍ତମାନ ପର୍ଯ୍ୟନ୍ତ ଚାଲିଥିଲା। WPCRL ଗୁଡାକ ସେତେବେଳେ ହେଇଯାଇଥିବ ସେ ଯେ ଫ୍ୟାମିଲି କୋର୍ଟ ଫ୍ୟାମିଲି ଏଠୁ ପରା କହିଦେଇଛି ଫ୍ୟାମିଲି କୋର୍ଟ ଅର୍ଡର ଟା ହବ ଡିଭିଜନ ବେଞ୍ଚ ରେ ଶୁଣାଣି ହବ। ଏଇଟା ଦେଖନ୍ତୁ ଏଇଠି an appeal preferred by shall be heard by bench of consisting of 2 or more judges। ତେଣୁ ସେଇଆକୁ ସେମାନେ ଆଖ୍ୟା କରିଦେଲେ ତାକୁ ଡିବି
In your lordship 3972 is also very clear in that in intellectual
no that is not maintainable। ସେଗୁଡାକ ଅନ୍ୟ ଅର୍ଡର ଗୁଡାକ ହେଲେ ସେଇଥିପାଇଁ 482 ଫାଇଲ କରନ୍ତି, ବଟ୍ ଏଥିପାଇଁ ସେମାନେ ଡିସିସନ କରିଦେଲେ ଯେ ନାଇଁ ଏଟାକୁ WPCRL, କାରଣ ଏଇଟା ଗୋଟେ CRL ପିଟିସନ ଆସିଥିବ ସେଠି ଯୋଉ ଫାଇଲ ହେଇଥିବ 125 ଟା ସେଟା ରେଜିଷ୍ଟର୍ଡ ହୁଏ କ୍ରିମିନାଲ ପ୍ରୋସିଡିଂ ନଟ ଏ ସିଭିଲ ପ୍ରୋସିଡିଂ ହିସାବରେ ହେଲା। କାରଣ ସିଭିଲ ପ୍ରୋସିଡିଂ ରେ ଯଦି ମେଣ୍ଟେନାନ୍ସ ମାଗିଥିବ ଦ୍ୟାଟ୍ସ ଏ ଡିଫରେଣ୍ଟ ମ୍ୟାଟର। ତେଣୁ କିନ୍ତୁ ବଟ୍ ଏଇଟା ଏଇ ଯୋଉଟା 125 ରୁ ଯେହେତୁ ଆରାଇଜ କରୁଛି ଏଟା କ୍ରିମିନାଲ ପ୍ରୋସିଡିଂ ଟାଇପ ର ଧରା ହଉଛି। ଇଟ୍ସ ଏ ସମରି ପ୍ରୋସିଡିଓର, ସେମ୍ ପ୍ରିନ୍ସିପଲ ଫଲୋଜ, ବଟ୍ ମାଜିଷ୍ଟ୍ରେଟଙ୍କ ପାଖରେ ଆଉ ଜୁରିସଡିକ୍ସନ ନାହିଁ, ପଳେଇ ଆସିଲା ଫ୍ୟାମିଲି କୋର୍ଟ କୁ ରାଇଟ୍। So now I think he is not interested now to that is why he is not even last date ରେ ମଧ୍ୟ ଯାହା ଦେଖୁଛି ମୁଁ ସେ କି appeal କରୁନଥିଲେ ଲାଷ୍ଟ ଟାଇମ ଏଟା ଆସିଥିଲା। there is no representation ସେଇ ଗ୍ରାଉଣ୍ଡ ରେ ଲେଖନ୍ତୁ non appeals for the
CRP ଫାଇଲ ହଉଛି CRP in the lower court, family court ରେ CRP
right, you are right। ଏଇଟା ହଉଛି CP, ସେଇଟା ହଉଛି CRP।
କିନ୍ତୁ ଏବେ ମୁଁ ଦେଖୁଛି ତା ଏଗେନ୍ଷ୍ଟ ଗୋଟେ ଫାଇଲ କରିଛନ୍ତି ଜଣେ CRL MP ଫାଇଲ କରିଛନ୍ତି। I think that maintainability କଥା ଉଠିବ, that has just been registered।
ନାଇଁ ଟାଇମ ଟୁ ଟାଇମ ଯୋଉ nomenclature ଚେଞ୍ଜ ହେଇଯାଉଛି ତେଣୁ ସେଇଥିପାଇଁ ବର୍ତ୍ତମାନ କଣ ହେଇଥିବ ମୁଁ ଜାଣିନି। ଆଚ୍ଛା ଲେଖନ୍ତୁ there is no non appeals for the petitioner when the matter was taken up on 27/6/2022 for the last time there was no representation from the petitioner and it was ordered on that day that if there is no representation, there would be no representation from the petitioner on the next day, the court would pass appropriate order. This WPCRL has been filed challenging the order dated 21/5/2013 passed in CRP number 21 of 2011 by the learned judge family court Bhubaneswar in granting interim maintenance in favor of the opposite party at the rate of rupees 5,000 per month from the date of application, that is 29/3/2011, till final disposal of the original proceeding. That is CRP number 21 of 2011, which is a proceeding under section 125 CRPC for maintenance. Stop. In view of the passage of time and the nature of order challenged, and since there is no representation from the side of the petitioner on the previous day and also today, the WPCRL stands dismissed for non-prosecution. Yes, next.
Note 3.
May I please, Your Lordship? Last occasion, my lord has directed on 25/8/2023 to state government, my lord, to take instruction about the victim girl, my lord.
No, what is your prayer in this?
Prayer, my lord, trace out the minor daughter of the petitioner who has been kidnapped by someone.
Kidnapped by
OP number 2 and 3.
Sandeep Behra.
My lord.
So that the FIR was lodged on 27/2023.
I guess.
What order has been passed previously?
So 25th August 2023, my lord. We direct the opposite part note 2 and
Just a minute. Let us see that order. 25/8/2023. Okay. List this matter on 30th. So we direct the opposite parties number 2 and 3 to take all efforts to recover the victim girl by next date. In the meantime, the status report detailing the action taken by the police be filed. So it's a case where specific government has been taken that this particular person has kidnapped and detained you. Okay. So what is the status?
Obtain the instruction, we are pursuing matter. We have not yet rescued the victim girl.
No, what about the accused?
He has switched off his mobile and we tried to nab him.
Again, the same problem. You are depending upon the clue to be provided by the accused.
Say, the accused is not available obviously in his house.
And the card is also above 17 years, maybe allowed with
No, that's it. It's all right. But I was searched the minor victim inside Pipili Bazaar, Sakhi Gopala, Delanga, Puri, and also in the nearest railway station, bus stand. The IO has conducted raid house. ଝିଅ ଘର ହଉଛି କୋଉଠି ପିପିଲି ରେ ଆପଣ ସେ ପିପିଲି ବଜାର ଫଜାର ବୁଲିବେ ତ ଖୋଜି ଆଉ ସେ ସେଇଠି ଥିବ ଭଲ
नहीं संदीप बेहरा को लोकेट कर ले नहीं
नहीं से तार मोबाइल ला स्विच ऑफ कर दे वी हैव ट्राइड टू
से किडनैप करछि जे कोन मोबाइल टा
ସେଇ ପ୍ରଶ୍ନ ତ ଆମେ ପଚାରୁଛୁ ଯଦି ସେ ସୁଇଚ ଅଫ୍ କରିଦେଲା ମୋବାଇଲ ଟା ଦି ଜଣ ଯାକ କେହି କଣ୍ଟାକ୍ଟ ନ କଲେ ଆପଣଙ୍କର କଣ ଏଜେନ୍ସିର ରହିଛି ଯେ କେମିତି ୱେ ଆଉଟ୍ ରହିଛି ନା ବସିଯିବେ ଚୁପଚାପ ମୋବାଇଲ କୁ ସୁଇଚ ଅଫ୍ କରିବେ ସେ କୋଉ ଦିନ ଯଦି ଫୋନ କରିବ ତାଙ୍କ କୋଉ ରିଲେଟିଭସ କୁ କି ଘର ଲୋକଙ୍କୁ ତାପରେ ଆପଣ ସେଟା ଟ୍ରେସ୍ ଆଉଟ୍ କରିକି ଯିବେ କୋଉ ଏରିଆରୁ ଆସିଲା
लेटेस्ट स्टेप्स व्हाट यू हैव
नहीं संदीप बेहरा फैमिली वाला को पचारिबे समथिंग ऑफ दैट सॉर्ट यू शुड डू
ଆପଣ ତ ୟା ଦେହରେ ଲେଖି ନାହାନ୍ତି ସେ ଯୋଉ ଆକ୍ୟୁଜ୍ଡ ର ସେ ତ ନାଁ ଦେଇଛନ୍ତି ନା ନାଁ ନ ଦେଇଛନ୍ତି ଅଲଗା କଥା ତାଙ୍କ ଇଏକୁ କୋଉଠି ଆପଣ ଲେଖିଛନ୍ତି କିଛି ନାହିଁ ତ ତାଙ୍କ ଘରକୁ ଯିବା ତାଙ୍କର ଟ୍ରେସ୍ ଆଉଟ୍ କରିବା ତାଙ୍କ ଫ୍ୟାମିଲି ମେମ୍ବର ସିଏ ସବୁ ଇଣ୍ଟ୍ରୋଗେଟ୍ କରିବା ତାଙ୍କର ଯୋଉ ପର୍ଟିକୁଲାର ଫୋନ ନମ୍ବର ତାଙ୍କ ଘରର ଯୋଉ ବାପା ମା ହଉ କି ଇଏ ହଉ ସେମାନଙ୍କ ପାଖକୁ କୋଉ ନମ୍ବରରୁ ଫୋନ ଆସୁଛି ସେ ଫୋନ ସବୁ କାହାର ତାପରେ ଦ୍ୱିତୀୟ କଥା ହଉଛି ସେ ପିଲାର ଆକାଉଣ୍ଟ ଥିଲା କି ନାହିଁ ଦେୟାର ଆର୍ ଡିଫରେଣ୍ଟ ୱେଜ୍ ସପୋଜ ବ୍ୟାଙ୍କ ଆକାଉଣ୍ଟ ଥିଲା କି ନାହିଁ ଗୋଟେ କଣ ଲେଖିଛନ୍ତି
I am replacing that to trace the victim, collect the data using mobile phone with the help of cyber cell Puri. I also made prayer to SP Puri to provide CDR and IME search of mobile number so and so of accused and obtain the CDR of mobile number so and so.
नहीं आगर गुटा कथा को आगर जेतरे मोबाइल फोन नथिला ए केस गुडा सॉल्व होनथला यू आर ओनली डिपेंडिंग अपन मोबाइल फोन
ए जो फोन नंबर गुडा काहार अक्यूज रो कोन अक्यूज रो तीनटा फोन आईएमएस सर्च ऑफ अक्यूज अच्छा अक्यूज रो जी तीनटा मोबाइल नंबर आउ ए जो सीडीआर डाटा ऑफ स्वान सो सेही मतलब माने अगेन यू आर banking on the we are making a query
Mr. Last parallel, I made prayer to BM of Canada Bank Teisipur branch of her account details.
Kaha account? Seri kahar account?
Accuser. Branch of her account detail and alternative mobile number, but we have not yet received. Still then, my lord, I will take
Suppose
the latest instruction.
ମନେ କରନ୍ତୁ ତାର ଆକାଉଣ୍ଟ ଅଛି ଆପଣଙ୍କର କଣ ତେଇଶିପୁର ବ୍ରାଞ୍ଚ ରେ ଆଚ୍ଛା ତାର ଲେଟେଷ୍ଟ ଲକ୍ଷେ ଟଙ୍କା ତା ଆକାଉଣ୍ଟ ରେ ଅଛି ସିଏ ଆକାଉଣ୍ଟ ୱିଡ୍ର କରିଛି ବାହାରକୁ ଦି ଜଣ ଯାଇଥିବେ ପଇସା ତ ପୁଣି ଦରକାର ହଉଥିବ ନା ଯଦି ସେମିତି କିଛି ନେଇ ନଥିବେ ଗଲା ବେଳକୁ ସୋ ୱିଡ୍ର କରିଛି ନା ୱିଡ୍ର କରିଥିଲେ କୋଉ ଏଟିଏମ ରୁ ସେଟା ୱିଡ୍ର ହେଇଛି ଜଣା ପଡିଯିବ ତ ସେଇ ଏରିଆରେ ଓବିୟସଲି ତ ଦ୍ୟାଟ ଇଜ ୱାନ୍ ପାର୍ଟ ନମ୍ବର ଟୁ ଆପଣ ଆକ୍ୟୁଜ ର ମୋବାଇଲ ଧରି ନିଅନ୍ତୁ ତାର ଆକ୍ୟୁଜ ର ମୋବାଇଲ ନାହିଁ ତା ଘର ଲୋକ ଫୋନ ରୁ ମାନେ ବାପା ହଉ ମା ହଉ କି ଭାଇ ଭଉଣୀ ସେଇ ଯୋଉ ନମ୍ବର କୁ ଆକ୍ୟୁଜ ଅନ୍ୟ ଫୋନ ରୁ କଲେ କଣ୍ଟାକ୍ଟ କରିବାର ସୁଯୋଗ ଅଛି ନା ନାଇଁ ସେ କରିପାରିବ ନା ନାଇଁ ଯଦି କରିପାରିବ ତାହେଲେ ସେଗୁଡାକ ଲୋକେଟ କରିପାରିବେ ଆପଣ ଏଇ ଯୋଉ ନମ୍ବର ଆସୁଛି ତାଙ୍କର ଏଇ ପର୍ଟିକୁଲାର ଡେଟ୍ ପରେ କାରଣ ଡେଟ୍ ଟା ନୁହେଁ ଯେ ଗୋଟେ ବର୍ଷ ହେଇଗଲାଣି ଆପଣଙ୍କର ସିଏ ବି ଡେଟ୍ ଦେଇ ଦେଇଛନ୍ତି କେବେଠୁ ଗଲା So the date is 20/7/2023 date of occurrence ଦେଇଛି 20/7/2023 ମାନେ ଆ ଭିତରେ 2 ମାସ ବି ହେଇନି ହେଲା ଯଦି 2 ମାସ ଭିତରେ ଏଇ ଯୋଉ ଆଉଟସାଇଡ ରୁ କେତେ ଫୋନ ଆସିଛି ମୁଁ କହୁନି ପିପିଲି ଲୋକାଲ ରୁ କି ଇଏ କରୁଛି ଆଉଟସାଇଡ ରୁ ଯୋଉ ଫୋନ ଗୁଡା ଆସିଛି ସେଗୁଡା କାହାର ଫୋନ ତ ସେଥିରୁ ଜଣା ପଡିଯିବ ମନେକର ଗୋଟେ କୋଉ ରିଲେଟିଭସ ର ବାହାରୁ ଆସିଛି ସେ ରିଲେଟିଭସ ରୁ ଯୋଉ ଫୋନ ଆସିଛି ସେଗୁଡାକ ଇଏ କରିହବ ହଁ ଆପଣ ମଧ୍ୟ ଇନଷ୍ଟ୍ରକ୍ସନ ଦେଲେ କଲ୍ ଆପଣ ରେକର୍ଡିଂ ସେମାନେ କରିକି ରଖିକିନା ଆପଣଙ୍କୁ ପ୍ରୋଭାଇଡ କରିବେ ଏ ପ୍ରକୃତରେ କିଏ ସେ ନମ୍ବରରୁ ଫୋନ କରିଛି କୋଉ ଟାଇପ ର
accuser of parents ର call detail କାଢିକିରି you can coordinate that.
That part I will take instruction. I have not taken instruction, only the instruction.
We are not here to advise you. The
ସବୁ
police should tell us what
these
exactly
are
they are
all
doing.
processes what my esteemed brother is telling that at a point of time when there was no mobile phone ସେତେବେଳେ ମଧ୍ୟ ରେସ୍କ୍ୟୁ ହଉଥିଲା ନା ନାଇଁ ଆଉ ତାହେଲେ ଗୋଟେ ମାଇନର ଝିଅଟା ଯାଇଛି ତାକୁ କୋଉ ଟାଇପ ର ତା ବାପା ମାଙ୍କର ମେଣ୍ଟାଲିଟି ରହୁଥିବ ହଁ ଆପଣ ଚୁପଚାପ ସେଠି ବସିକିନି ସେ ଲୋକାଲ ଥାନା ଲୋକାଲ ଏରିଆରେ ସେ ପିପିଲି ବଜାର ସେଇଠି ବୁଲିବେ ସେ କଣ ଡେଲାଙ୍ଗ ବସ୍ ଷ୍ଟାଣ୍ଡ ହଁ ଏଗୁଡାକ ବୁଲିବେ ସେ
Kidnap କରି ନେଇକି ସେ bus stand ରେ ଠିଆ ହେଇଥିବ ନା market ରେ ଠିଆ ହେଇଥିବ।
କଣ କହୁଛନ୍ତି ଏମାନେ ସବୁ so ଦେଖନ୍ତୁ the in portions of the order dated last order of the 25/8/23 the London Council for the state has produced status report dated 30/8/2023 of the IIC Pipili police station. On going through the status report, we are not satisfied with the steps taken by the IIC to trace out the victim. However, the Land Council for the state seeks some further time to obtain concrete information as to about the development made in the meantime and whether there is any attempt made to verify whether the accused who is having a account in Canada Bank of the Sipur branch, as mentioned in the status report, has been the account has been any cash has been it is in it has been used from any ATM to withdraw money from the accounts of the accused, which is lying in the Canada Bank of Tesipur branch, as mentioned in the status report. Further instructions shall be taken whether any CDR of the family members of the accused has been verified to assist the investigation to trace out the victim or not, and whether the family members of the accused have been interrogated in that respect. list this matter in the week commencing from 25th September 2023. 3 copy of the order be handed over to the Land Council for the state. Mr. Das, in one case, I think you have told you sit with these police people and collect that what method we were interested in. They must have some certain guideline that if this is the state of affair in which the accused and the victim both switched off the mobile, both do not keep any contact with their family members, then how they will
One case I am another matter. They police take the interest. It's a solved matter because one kidnapped a girl of 10 years matter from the airport of Bangalore of Odisha girl matter of Chandrasekhar. So that girl was kidnapped from the airport itself, from the lobby. He went, he was playing, and at that moment, the fathers and mothers had no attention toward the child. In that meantime, they kidnapped the girl. And at that moment, the CC camera was there. They covered their face, and the cap. But thereafter, one point, there is no camera.
outside of the airport.
Inside the camera. They keep that girl inside the bathroom for 48 hours. That girl was there. One lady was there, but nobody is surprisingly not asking about it. The sweeper asked the particular girl, my lord, the woman, my lord. He told her his father is gone. We are waiting. We are flight and so and so. But the way they got it, my lord, the one person of the from Odisha, my lord. He was following the family through Facebook, my lord. The Facebook, he has made a friend request 1 month before. They accepted that, and thereafter they just upload their photos when they move towards the Chennai, Bombay, and travel, my lord. So he was following the account, my lord. There, they find out how many days, who are the friends requested and accepted by the particular account, my lord. So from that, they got that within 1 month, one boy has been accepted. So they tried to find out who is that person. So they got that from the IT, that is his house at Chandrasekhar. They went there. And they found the boy is not there. Father, mother is there. They asked about the boy. But he's a IT sector guy. He's was working Satyam computer. And they told that, parents told that now he is working on the work, home. But he is earning a good amount prior to the Satyam, after the Satyam. So they asked them, they told them he has gone somewhere out, then he never informed us. So somehow they have a suspicion that he has gone there. So then he tried to, how he left the house, from which date and how. The date, they told that matches with the date of travel, my lord. Thereafter, they tried that he must be gone through flight or train, or they tried to check out all the
names of the
but not find. So then they asked the parents again. They went and asked how he moved from the house. One taxi cab, my lord. So then they tried somehow cab they find out the travel agency. From that, then again the driver. That driver went to the Vizag, my lord. He left in Vizag. He took a flight from Vizag to Bangalore. Again, very cunningly he has done it. So somehow they got it. The link there, the travel there, within 40 hours they were doing it. So they find out the boy in a hotel, my lord. So they reached there and they found that the person who is kept in the Bangalore airport in the Vizag, my lord, just the appearance. So somehow they got the taxi driver and went there and find out the guy. So from there, my lord, they found that there is a totally group of persons in international, and they are kidnapping the child of within 13 years. And there is a trading in the nets.
Right.
They are doing all these things.
So they asked, where is that girl now? No, he told them in the inside of the Bangalore
Airport.
So immediately, now what is the plan? Now within another 6 hours, the visa and passport will come from the Dubai, and he will live there. So the visa and so how they are getting from the Dubai, they explain all everything. So because that girl is belong to a police officer now. So all the steps were taken at that moment that they rescue the girl.
So therefore, the consequence is so serious.
Yes,
if they would not have done it.
No. And again, my lord, in Bangalore, my lord, when they take the help of the commissioner, their police, my lord, they told that within 1 month, there are 40 cases of missing case from the airport.
Just see.
40 cases. And from this guy, they rescued 10 girls.
So therefore, they just see
Yes, ma'am.
what kind of
I understand.
efforts one has to take.
Yes, sir.
Can't depend upon only the mobile phone.
Because suppose
Unless they take the proper initiative and proper
somebody, you see, just what they were doing. They suppose the girl is aged about 17 years, 17 years few months, and so they went, and they must be staying somewhere in the friend's house of the boy or the girl at some other place. May not be Odisha, and they obviously will definitely switch off the mobile because they know that once we use the mobile phone, our mobile phone will be tracked.
Unless until, my lord, there are a lot of like, my lord, suppose they are using internet or their Facebook or Instagram, my lord, or to call to anybody else, friends or family members.
And I tell you, the youngsters will never stop using mobile.
Yes,
somehow the other
Right,
they
right.
will use.
The
The social media, something or the other, they'll definitely
They'll
use.
do. They will stay for a short period, not to do all these things, but after some days they will start
They
again.
will do.
So that is you have to watch in that
and
way.
now, of course, sometimes they become more careful that yes, we have account. Once we use it, also they can know that from where is the location of that ATM from which we are drawing the money. So
Yes, madam.
they will not use that account. They will not use their account. They will take something with them, maybe like in gold ornaments or like at that time. It's a
Some days they will manage that,
right.
but thereafter,
Right.
definitely.
So that is that is why the discussion is that some innovative
Yes, ma'am.
ideas are to be
that depends on the investigation agency who
yes,
is doing that. Totally.
because
out of box.
out of box you have to think, and
Otherwise they will not.
crime has been nowadays. It's not that it is committed in everybody's front like that. The old investigation method that would not do now.
New methods.
Right, right. You may succeed. You may succeed such type of thing in local areas, village areas, but
law affairs in some
right, that is they are much matured nowadays. From the age of 12, 13, they are using this.
Using the mobiles and getting the internet, and they are knowing better more than
right,
us.
right. They are every time they are whatever. They are not going to play outside. They will always use and
days gone playing with the
right.
in the field. That days gone.
Okay. So this matter will be listed.
And now
on
the police also advising that don't use the mobiles, internet, and when we are traveling or internet means the social media, don't upload any photos because they are tracking you throughout the your travel. So if you're uploading the mobile, I'm here, I'm there, I'm got the mobile during that period.
Your movement is tracked and
right.
They will
once you upload something in the mobile, it may not be you. It may be one of your family members who might not be knowing that this my mobile has been used by my son or. But ultimately, once you upload it, so
they are
even if you delete it, also the record will be there. So
selfie taking airport,
right.
All these things.
status and all.
Yes, ma'am.
Yes, next.
Item 4.
My lord, I am appointed through legal.
No, what is this letter of Senior Superintendent कौन गुड़ा अच्छी कौन देखी? At flag A. Letter टा दियो. इधर तो हाँ ठीक है अच्छी.
Flag A.
This is flag A. 12/9/2023. With reference to the letter cited, I am to inform you that the convict Hadi Dhanga Gada Maji alias Chalan, son of Soon, has been convicted under section so and so, has been transferred from this jail to Biju Patnaik Open Air Ashram, Jumuhari, on so and so in confinement. Okay. That information was received. Only that much. You have been engaged by the legal aid board? When? When you were engaged? Paperwork ta bahar karo.
On my lord, 31/7/2020.
All right. So
There was a direction that you are supposed to have you contact the accused
My lord,
through visual mode. Have you done it?
my lord, I am unable to contact
now it's a case under 302.
two man.
Okay. Come to the charge. Let us see that what is the charge. Only 302 or other offense?
Only 302.
So come to the relevant page.
My lord, page 7,
Paper.
my lord, internal page 5 of the judgment, page 7.
No, come to the charge frame page. Charge under page 14. Read out it.
The exemption of the activity. The date of fatwa taken before me, Sri S.S.MISHRA in
Read it from the past. That name is there. First, you on or about 29/5. Yes.
my lord,
3 p.m. The village.
my lord, it is question number 1. It is transferred from the testimony of the PW1.
अरे कौन पढ़ुचंदी?
Page 14.
We are telling you about asking you to read the charge. You are reading the accused statement. Yes.
That is you on or about to the 29/5/1999 at about 3 p.m. at village Goigunda committed murder intentionally causing the death of S.K.SAHOO and thereby committed an offense punishable under section 302 of the Indian Penal Code and within my cognizance.
All right. So it's
Second.
the name of the deceased is S.K.SAHOO. Date of occurrence is 29/5/1999. Time is 3 p.m. And place of occurrence is village Goiguda, right? Now you come to the FIR. Let us say FIR is at page 10. So come to the relevant page, that is at page 12. Read it out.
Mu Sri Lakshmi Sita Pita Hadi Sisa Ramo Goiguda Thana Mudli Poda.
No, the informant is PW.
Informant my lord, PW 4, my lord. He had and orally.
Okay, just a minute. So informant is name hala taro kono Lachanda
Lakshmi Sisa.
Acha Lachmi Sisa.
My lord.
Is PW4.
My lord.
Okay, read it out.
Mu Sri Lakshmi Sisa Pita Hadi Sisa Gramo Goiguda Thana Mudulipada Aji ta 29/5/2019 ଶନିବାର ରାତ୍ର 9ଟା ବେଳେ ମୁଁ ଆମ ଗାଁର ହାଡି ବନୟକ
ହାଡି ବଡନାୟକ, ଶୁକ୍ରା ବଡନାୟକ ଓ ଅନ୍ୟମାନଙ୍କ ସହିତ ମୁଦୁଲିପଡା ଥାନାକୁ ଆସି ଥାନା ବାବୁଙ୍କୁ ତୁଣ୍ଡ କଥାରେ ଦେବା ଏତଲା ଏହିକି ଯେ ଗତ 3 ବର୍ଷ ତଳେ ତଳାଗୁରୁମ ଗ୍ରାମର ସନ୍ୟା ଚାଲାଣର ପୁଅ ଲକ୍ଷ୍ମୀ ଚାଲାଣ ଆମ ଗାଁର ସନ୍ୟା ସିସାର ଝିଅ ଶୁକ୍ରି ସିସାକୁ ବାହା ହୋଇଥିଲା, କିନ୍ତୁ ଲକ୍ଷ୍ମୀ ଚାଲାଣ ସେଇ ଝିଅକୁ ଭଲ ଭାବରେ ନ ଦେଖିବାରୁ ସେଇ ଝିଅ ଗତ ତା 26/5/19 ତାରିଖରେ ପଣ୍ଡାପଡାର ଗୋଟିଏ ପୁଅ ସାଙ୍ଗରେ ପଳାଇ ତାକୁ ବାହା ହୋଇଗଲା। ଉକ୍ତ ଝିଅର ସ୍ୱର୍ଗଦା ପାଇଁ ତୁଳା ଗୁରୁମର ଲୋକମାନେ ଉଡାଙ୍ଗଗୁଡା ଯାଇ ସେଇ ଝିଅର ମା ପାଖରୁ 5 ମୁଣ୍ଡ ଗୋରୁ ଗାଈ ନେଇଯାଇଥିଲେ। ସେଇ ଗୋରୁ ଗୁଡିକ ପରେ ଘରକୁ ପଳାଇ ଆସିଲେ। ଏଥିରେ ରାଗି ଯାଇ ଆଜି ଲକ୍ଷ୍ମୀ ଚାଲାଣର ସାନ ବାପା ହାଡି ଚାଲାଣ, ପିତା ଶୁକ୍ରା ଚାଲାଣ ଗାଈ ଗୁଡାକୁ ଆସି ସମୟ ପ୍ରାୟ 3 ଘଣ୍ଟା ହେବ ଧନୁତୀର ଧରି ସମସ୍ତଙ୍କୁ ଡରା ଭିଡା କରିବାରୁ ଗାଁର ସମସ୍ତ ଲୋକ ଲୁଚିଗଲେ। ଉକ୍ତ ସମୟରେ ମୋର ସାନ ବାପା ଶୁକ୍ରାଶିଷା
He is the deceased.
ଶୁକ୍ରାଶିଷା ତାର ଘର ପିଣ୍ଡାରେ ବସିଥିଲା। ତା ଉପରକୁ ହାଡି ଚାଲାଣ 2 ଗୋଟି ତୀର ବିନ୍ଧିଦେଲା। ସେଇ ତୀର ଶୁକ୍ରାର ଛାତିରେ ଏବଂ ଡାହାଣ ପାଖ ପେଟରେ ଗଳିଯିବାରୁ ସେ ସେଇଠାରେ ପଡି ମରିଗଲା। ଏତିକି ବେଳେ ହାଡି ଚାଲାଣ ସିଟି ମାରି ପାଟି କରି କହିଲା, ତୁମ ଗାଁରେ ଗୋଟିଏ ପୋଢ ମରିଛି, ଆସ ଦେଖିବ କହି ଧନୁତୀର ଧରି ଚାଲିଗଲା। ଉକ୍ତ ଘଟଣା ଶୁକ୍ରା ସିସା, ହାଡି ସିସା ଓ ଅନ୍ୟମାନେ ଦେଖିଛନ୍ତି। ତାପରେ ଆମେ ସମସ୍ତେ ପାଖକୁ ଯାଇ ଦେଖିଲୁ ଶୁକ୍ରା ଛାତିରେ ଏବଂ ଡାହାଣ ପାଖ ପେଟରେ 2ଟି ତୀର ଗଳି ଯାଇଛି। ରକ୍ତ ବାହାରି ଶୁକ୍ରା ମରିଯାଇଛି। ମୁଁ ତୀରର କାଠି ଅଂଶକୁ ଭାଙ୍ଗିଦେଲି। ଗାଁରେ ପଞ୍ଚାୟତ କରି ଶୁକ୍ରାର ମଢକୁ ଥାନାକୁ ଆଣିବାକୁ ଚାହିଁଲା ବେଳେ ଶୁକ୍ରା ପୁଣି ଧନୁତୀର ଧରି ଆସି କହିଲା, ମଢକୁ ନେବାକୁ ହବ ନାହିଁ, ଯେ ମଢକୁ ଛୁଇଁବ ତାକୁ ବିନ୍ଧିଦେବି ବୋଲି ଡରାଇବାରୁ ତାର ମଢକୁ ଧରି ଆଣି ପାରିଲୁ ନାହିଁ। ମଢ ଗାଁରେ ପଡି ରହିଛି। ଏଣୁ ଏହା ତଦନ୍ତ କରାଯାଇ ଦୋଷୀକୁ ଦଣ୍ଡ ଦିଆଯାଉ। ଲେଖି ପଢି ଶୁଣାଇ ଦେବାରେ ମୁଁ କହିବା ମୁତାବକ ଠିକ ଥିବାର ଜାଣି ମୋର ସନ୍ତକ ଦେଲି।
Who all are the eyewitnesses?
My lord, PW5, the only eyewitness basing on which
PW5 name?
My lord Shukra Sisa.
ଶୁକ୍ରା ସିସା ପରା
ସେଇ
deceased.
ଡିସିଜ ନା ଯାହାବି ୟା ନା ବି
ଓ ଆଉ ଗୋଟେ ନାଁ ଆସୁଛି ସେ ଏକା ନା?
ବାପା ନା କଣ?
ଆଚ୍ଛା,
ଶୁକ୍ରା ସିସା
ହାଡି ସିସା। ଆଚ୍ଛା।
ଏଇ ଯୋଉ PW5 ର ବାପାଙ୍କ ନାଁ
ହାଡି ସିସା।
Please read that PW5's evidence.
My lord, page 21. My lord. I know the accused in the dock and the deceased. The occurrence took place about 5 years back. The accused came to our village and picked up quarrel with Shukra Sisa. And when Shukra challenged as to why he was quarreling, the accused shot an arrow at him and committed his murder. I have no further knowledge. Cross against it is not a fact that I did not see the occurrence and that I was absent from the village. The occurrence took place on Saturday and I was examined on the next day by the police. It is not a fact that I am in inimical terms with the accused and that for reason I am deposing falsehood.
You see the manner in which in a 302 case the counsel have been state defense counsel. What sort of questions have been put? Nothing has been put except giving suggestion. That is why the Honorable Supreme Court says that at least 10 years of practice in criminal law, it should be there for engaging a counsel. A witness as eyewitness to the occurrence, an entire case is based on his testimony. 2-line cross-examination, he is an eyewitness, nothing has been put. How you will in a appellate court, what you will do? It's not a fact that I did not see the occurrence. One suggestion that I was absent, he denied. Occurrence took place on a Saturday. whether it is a Saturday, Sunday, Monday, why this question has been put, there is nothing. I was examined on the next day. It's not a fact that I'm in any return. Matter over.
Completely hopeless.
What can you do in
My lord, in this case,
What else?
my lord, there is no corroboration with the eyewitness, my lord, regarding
how, Mr. How? Unless you see, corroboration is a secondary aspect. One witness has stated like this. If we hold that the witness evidence has not at all been shaken in the cross-examination, then if that evidence is acceptable, it is found to be clear, cogent, then solitary evidence is sufficient to.
only
And
in this-
obviously, it must be getting corroboration from the medical evidence.
No.
Come to the, let us say that, who is the doctor who conducted
doctor
it?
has not been examined in this case.
Why?
Doctor is not again.
No.
Why?
I am just going to tell that.
No, why? With that PM report has not been marked.
PM report exhibit 7, my lord.
Who has marked that?
IO, PW7.
Very nice.
No. Why IO has marked it? Why? Who is the IO? PW7.
7.
Let us come to that portion.
6. Para 6.
Para 6. Let us see. I received the postmortem report.
In respect of the deceased
On,
by
on,
report,
on 777, I received the
exhibit 7. I
No,
also made
let us come to the postmortem report then.
exhibit 7.
exhibit.
Exhibit বার করো।
Exhibit করো।
List of exhibits. তারপরে থিব exhibit postmortem report হচ্ছে exhibit কেতে
7.
7 6 this is 7 okay ଏଟା କଣ ବଙ୍କା ଏମିତି କଣ ଦେଖୁନାହାନ୍ତି ଇଆକୁ କରିଛି ଏମିତି ରଖିଛି ପୋଜିସନ ତ ବୁଲା ଆରେ ବୁଲା ହଁ
করো exhibit।
this is exhibit 7 so ଆରୋ intact ଆରୋ ଲାଗିନ୍ ରହିଛି ତା ଦେହରେ thorax portion ରେ ଦେଖଉଛି body of supra got it আসলে তারপরে পেজ কি করে যাবে না তারপর এটা বুলা हाँ ये ऊपर लिखा है the body of the supra how to go through ये जगह right the body of supra sisa of aged about 58 years and so and so okay decomposed acha eta wound side la perforated wound of so and so arrow inside the body right side just lateral to the sternum in third intercostal space then perforated wound on
right side
right এটা ওটা কোন লেখা আছে
side right
right no below one so
25
so it appears that twice he was hit তার মানে ଦିଟା ତୀର ହଁ ଦିଟା wound ପାଇଲା ଏବଂ ତୀରଟା ଲାଗିଥିଲା ମଧ୍ୟ ଏଠି କହୁଛି କାରଣ ତାପରେ ଏଇଠି ଲେଖା ହେଇଛି thorax ରେ ଲେଖା ହେଇଛି thorax column roman 3 এইটাରେ ଲେଖା ହେଇଛି arrow inside the
IC space.
Okay, so now if we'll come to next page, that is page number 8 of Bula, Taporata page to Nechetan. Our second page roju postmortem report. Where was he? E page to Bula. Bula. E page to Bula, second page to Bula. No, Setan. बैक कर बैक तौक नहीं आस ऊपर 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 बैक बैक हाँ okay the body of Shukra having two arrows two arrows shot
inside
both arrow inside the body, one in the right side, third intercostal space, personal lungs and inside the chest cavity, and another arrow inside the abdominal cavity right side, so below 12 so gote ए portion ने पसिची lungs को affect करिची आ गोटे rib रे रही जाइछि 12th rib रे तळ आड़ को रहिछि, so that is how he has stated also the cause of death hemorrhage and hypovolemic shock due to arrow shot. So dita shot ଆପଣ ମାରିଛନ୍ତି and that is also the story narrated in the FIR. FIR ରେ କହିଲା ମଧ୍ୟ ଯେ ତା ଉପରକୁ ହାଡି ଚାଲାଣ 2 ଗୋଟି ତୀର ବିନ୍ଧି ଦେଲା, ସେହି ତୀର ଶୁକ୍ରାର ଛାତିରେ ଓ ଡାହାଣ ପାଖ ପେଟରେ ଗଳି ଯିବାରୁ ସେ ସେଇଠାରେ ପଡି ମରିଗଲା। ଏତିକି ବେଳେ ହାଡି ଚାଲାଣ ସିଟି ମାରି ପାଟି କରି କହିଲା ତୁମ ଗାଁରେ ଗୋଟେ ପୋଡ ମାରିଛି, ଆସ ଦେଖିବ କହି ଧନୁ ତୀର ଧରି ଚାଲିଗଲା। ତାପରେ ଉକ୍ତ ଘଟଣା ସୁଆଣ ଅନ୍ୟମାନେ ଦେଖିଛନ୍ତି। ତାପରେ ଆମେ ସମସ୍ତେ ପାଖକୁ ଯାଇ ଦେଖିଲୁ ଶୁକ୍ରାର ଛାତିରେ ଓ ଡାହାଣ ପାଖ ପେଟରେ 2ଟି ତୀର ଗଳି ଯାଇଛି। And inquest report must be also like that. Come to that inquest report. सेटा बाहर कर एग्जिबिट टा केते हेतला सेटा क्लिक करो
exhibit 4
exhibit
4
स्क्रॉल डाउन कर दो तो एटा केते नंबर है स्क्रॉल डाउन एटा आइडिया अच्छा सी हला ना दिया गला शुक्रा। अच्छा प्लेस वेयर बॉडी फाउंड मुथापा ता निज घर बारंडारे उपरକୁ मुह करी ता उपरे धळा लुगा घोड़ा होई थाई, मुह बाम ओ मोड़ी होई थाई, पश्चिम को मुंड पूर्व को गोड़ थाई मरी पड़थिवार पाया गला। डेस्क्रिप्शन ऑफ द कप मुताबा को बाहर को आनी पश्चिम को मुंड रखी सुआई पूर्व को गोड़ देह सीधा करी हाथ अधा बंद थाई छातीर डाहाण पट और डाहाण पाक पेटरे 2टी तीर गड़ी थाई बिंधा होई थाई रक्त बाहरुथिबा अवस्थारे तीरर काठ अंश भंगा जाई पाटी अधा खोला जाई आखि बंद थाई मुह फुली थाई मरी पड़िथिबार पाया गला। मुतफाको साक्षी मानक सामनारे उल्टो पाल्ट करी देखाइबारे मुताफार डाहाण पाख छाती और डाहाण पटर तड़ी पेट उपरକୁ 2 गोटी तीर सुआंशु पाया गला। अधा सी okay, who are the come to the paper book अन्य साखी गुड़ा किए सब कौन होई छ
अन्य साखी PW1 सीजर इनक्वेस्ट
PW1 हला सीजर वेयरिंग अपैरल्स तापर 2 हला
कांस्टेबल से इनक्वेस्ट
ओके इनक्वेस्ट ताने 3 कांस्टेबल और कमांड सर्टिफिकेट छ 4
इन्फॉर्मेंट 5 आई विटनेस 6 doesn't support
run 5 हला आई विटनेस
Chari was there in the spot? No.
he had and
बच्चा देखियो तो एफआईआर आउट ये देखियो
Chari ta dekho like
आउट ये पढ़िले एफआईआर टा मूल रहउछ
मु श्री लक्ष्मी सीसा पिता हाड़ी सीसा ग्राम गईगुड़ा थाना मुदलीपड़ा ଆଜି ତା 29/5/19 ତାରିଖ ଶନିବାର ରାତ୍ର 6 ଘଣ୍ଟା ବେଳେ ମୁଁ ଆମ ଗାଁର ହାଡି ବଡନାୟକ ବଡନାୟକ ଓ ଅନ୍ୟମାନଙ୍କ ସହିତ ମୁଦୁଲିପଡା ଥାନାକୁ ଆସି ଥାନା ବାବୁଙ୍କୁ ତୁଣ୍ଡ କଥାରେ ଦେବା ଏତଲା ଏହିକି ଯେ ଗତ 3 ବର୍ଷ ତଳେ ତଳାଗୁରୁମ ଗ୍ରାମର ସନ୍ୟା ଚାଲାଣର ପୁଅ ଲକ୍ଷ୍ମୀ ଚାଲାଣ
କିଏ ଲକ୍ଷ୍ମୀ ଚାଲାଣ କିଏ?
ये author
ଲକ୍ଷ୍ମୀ ଚାଲାଣ ମାଇ ଲର୍ଡ ନେଫ୍ୟୁ ଅଫ ଦି
ନାଇଁ ସିଏ କିଛି ଏକ୍ସାମିନ ହେଇନି
नहीं नहीं PW4 ना से
ନା
ନାଇଁ,
no,
ନାଇଁ।
ସେ ଲକ୍ଷ୍ମୀ ସିସ୍ତା
लक्ष्मी
ହଁ ତ ଲକ୍ଷ୍ମୀ ଚାଲାଣ ଆମ ଗାଁର
ଲକ୍ଷ୍ମୀ ଚାଲାଣ ଆମ ଗାଁର ସନ୍ୟା ସିସାର ଝିଅ ସୁକ୍ରି ସିସାକୁ
ସିଏ ବି ଏକ୍ସାମିନ ହେଇନି।
ନୋ ମ୍ୟାନ୍
ଆଚ୍ଛା ବାହା ହେଇଥିଲା।
ବାହା ହୋଇଥିଲା
ହୁଁ
କିନ୍ତୁ ଲକ୍ଷ୍ମୀ ଚାଲାଣ ସେଇ ଝିଅକୁ ଭଲ ଭାବରେ ନ ଦେଖିବାରୁ
ହୁଁ
ସେଇ ଝିଅ ଗତ ତା 26/5/19 ତାରିଖରେ ପଣ୍ଡାପଡାର ଗୋଟିଏ ପୁଅ ସାଙ୍ଗରେ ପଳାଇ
ଓକେ
ତାକୁ ବାହା ହେଇଗଲା।
ହୁଁ
ଉକ୍ତ ଝିଅର ସ୍ୱର୍ଗଦା ପାଇଁ ତଳା ଗୁରୁମର ଲୋକମାନେ
ହୁଁ
ଉଡାଙ୍ଗ ଗୁଡା ଯାଇ ସେହି ଝିଅର ମା ପାଖରୁ 5 ମୁଣ୍ଡ ଗୋରୁ ଗାଈ ନେଇଯାଇଥିଲେ।
ଓକେ
ସେହି ଗୋରୁ ଗୁଡିକ ପର ଘରକୁ ପଳେଇ ଆସିଲେ।
ହୁଁ
ଏଥିରେ
ପଳେଇଲା ମାନେ ଝିଅ ଘରକୁ ପଳେଇଲେ
ହଁ,
ପୁଣି।
ସେ ତା ମା ପାଖକୁ ପଳେଇ ଆସିଲେ।
ହଁ ତାପରେ
ଏଥିରେ ରାଗି ଯାଇ ଆଜି ଲକ୍ଷ୍ମୀ ଚାଳନ୍ଦର ସାନ ବାପା
ଆଚ୍ଛା ଲକ୍ଷ୍ମୀ ଚାଲାଣ କିଏ? ଓ ଯୋଉ
ଲକ୍ଷ୍ମୀ
ସେ
ଚାଳନ୍ଦ ମାନେ
ସେ ଯୋଉ ପୁଅଟା
ପୁଅଟା
ଆଚ୍ଛା,
ଯାହା ସହିତ ବାହାଘର ହବାର
ହଁ ହଁ ହଁ
ଲକ୍ଷ୍ମୀ ଚାଲାଣର ସାନ ବାପା ହାଡି ଚାଲାଣ ଆपिଲାଣ୍ଡ ପିତା ଶୁକ୍ର ଗାଈ ଗୁଡାକୁ ଆସି ସମୟ ପ୍ରାୟ 3 ଘଣ୍ଟା ହେବ ଧନୁତୀର ଧରି ସମସ୍ତଙ୍କୁ ଡରା ଭିଡା କରିବାରୁ ଗାଁର ସମସ୍ତ ଲୋକେ ଲୁଚିଗଲେ। ଉକ୍ତ ସମୟରେ ମୋର ସାନ ବାପା ଶୁକ୍ରା ସିସା ତା ଘର ପିଣ୍ଡାରେ ବସିଥିଲା।
ହୁଁ
ତା ଉପରକୁ ହାଡି ଚାଲାଣ 2 ଗୋଟି ତୀର ବିନ୍ଧିଦେଲା। ସେଇ ତୀର ଶୁକ୍ରାର ଛାତିରେ ଏବଂ ଡାହାଣ ପାଖ ପେଟରେ ଗଳି ଯିବାରୁ ସେ ସେଇଠାରେ ପଡି ମରିଗଲା।
ହୁଁ
ଏତିକି ବେଳେ ହାଡି ଚାଲାଣ ସିଟି ମାରି ପାଟି କରି କହିଲା, ତୁମ ଗାଁରେ ଗୋଟିଏ ପୋଢ ମାରିଛି ଆସ ଦେଖିବ କହି ଧନୁତୀର ଧରି ଚାଲିଗଲା। ଉକ୍ତ ଘଟଣା ଶୁକ୍ରା ସିସା ହାଡି ସିସା ଓ ଅନ୍ୟମାନେ ଦେଖିଛନ୍ତି।
ହୁଁ
ତାପରେ ଆମେ ସମସ୍ତେ ପାଖକୁ ଯାଇ ଦେଖିଲୁ ଶୁକ୍ରାର ଛାତିରେ ଓ ଡାହାଣ ପେଟ ପାଖରେ 2ଟି ତୀର
ବର୍ତ୍ତମାନ ହେଲା ଯଦି ୱାର୍ଲ ଭିତରେ ଯାହା ଏଭିଡେନ୍ସ ଆସୁଛି PW5 ରେ ୱାର୍ଲ ବେଳେ 2ଟା ତୀର ମରା ହେଇଛି କିନ୍ତୁ ସିଏ କହୁଛି ସଟ୍ ଆନ୍ ଆରୋ ଗୋଟିଏ ତୀର ମାରିଛି ବୋଲି କହୁଛି ବଟ୍ whereas ପୋଷ୍ଟମର୍ଟମ ରିପୋର୍ଟ ଅନୁଯାୟୀ 2ଟା ତୀର ମରା ହେଇଛି ଇନକ୍ୱେଷ୍ଟ ରିପୋର୍ଟ ବି 2ଟା ତୀର ପଶିଥିଲା
FIR भी 2टा ତୀର
FIR ବି 2ଟା ତୀର
chemical
ବି 2ଟା
examination report
ହୁଁ
the chemical examination report one arrow has no blood,
ହୁଁ
another arrow blood but no opinion whether it is a blood of a human or not.
ନାଇଁ
The group
one arrow ହଉଛି oral evidence 2 arrows ହଉଛି recover right
recovered from the body
from the body ହେଲା
Said.
now how do you bring suppose we accept this version of PW5 because there is no cross examination, can you bring the case within the purview of not under 302?
My lord,
Have you brought any citation to that?
My lord, pardon my lord, on yesterday I have some problems for that reason I had not.
କେମିତି କହିଲେ କେମିତି ହବ ଆପଣ 302
it is on only on sudden provocation my lord, due to quarrel between the appellant and the deceased.
ବାବୁ ସାଇଟେସନ ନ ଖୋଜିଲେ କେମିତି ହବ? ତମେ ସାଇଟେସନ ନ ଆଣିକିନି ତା ଦେହରେ ଆନାଲିସିସ ହେଇଥିବ ମନୁପାତ୍ର ଭାତ ମନୁ ସର୍ଚ୍ଚ ମା ଲେଖ 2 arrows ARRO WS ଟିକେ ଛାଡିକିନି short SHOT ଲେଖ
T
ହଁ
short
ତାପରେ ଲେଖ chest ହେଲା 304 part 2 pay the part to II ସେମିତି ନୁହେଁ dita I capital I IPCT छाड़ेंगे I.P.C अच्छा डॉट मारो डॉट दिया P पर डॉट दी जଣା पड़नी गैप दिया जी बेसी IPC है ना I.P.C और लगा दो IPC
कम करो
स्पेस कम करो अरे
सीटा
कौन
करो आई पर स्पेस कम करो
I
आई डॉट पर स्पेस कम करो हाँ
C
सी
टाइप भी
को
लगा
पूरी करो
हाँ तापर ये पर C पर ऊपर ऐसा लको क्वार लिख दियो QUA it are 9 paragraph even otherwise looking at the so answer the nature of dispute which occurred suddenly and in the heat of passion and out of anger the appellant has committed the offense there was no premeditation or it was a not a pre-planned murder number of so carry bows and arrows with them therefore it cannot be said that the appellant was intending to kill so as per the evidence common record there was no previous dispute and enmity between the appellant and his brother. The dispute arose in a heat of passion and therefore in view of the law laid down by the so this one would have 304 part on ultimately it arose short case qual okay factual hospitality the accused shot an arrow which hit on the left side chest of Padam Singh deceased due to which he fell down and died at the spot. Based on this one, so at here, two penetrating wounds were found on the chest apart from swan. So, okay, that was the addition, Roji.
So the accused was drunk.
Shankar
Pardon?
versus
Accused was drunk.
State
No, madam.
MP at a housing. अरे ये तक चालू नहीं हुआ हाँ ठीक माउस इफेक्ट असुनी तो ये ठीक है सर wait there Monu MP 3546 2022 all right back then results some of our court Odisha chapter edition ଅଛି ଦେଖ 1218 hitting the arrow on the chest okay এটা কোন in the case of Swanso Reliant Apex Court has pronounced that though there was no sudden fall as stated by the appellant, but shooting of the arrow without accuracy of the place to hit, the act of the accused causing the RO sought injury and the death of the deceased amount to culpable homicide not amounting to murder. Lord Sachaita Lagala Lakshman versus State of MP, reported in AIR 2006, Supreme Court 3240. So, though the facts distinguishable can yet the ratio applicable in as much in the present case, there was provocation from the side of the deceased and in the retaliatory only the RO was sought, and the prosecution does not say whether it was aimed to kill him, though the RO sought injury killed the deceased. Under such circumstances, we set aside the order of conviction, so on and so forth. So this is next. Another is results. Then Jallu, এটা কেতে রিপোর্ট এলা উদ্দে মাঝে UDE উদ্দে কোন থানা উদ্দে নায়ক versus State of Orissa report करले पूरे date of judgment हला 20/8/2008 मनु OR 0797/2008. Okay, next jiva see results ku jiva. Then we'll come to Jallu Maji versus State. The case of the prosecution that the appellant made so happens to be veto the appellant and his wife residing in the so there was quarrel. At that time, Dinu Maji's father-in-law reached near the entrance road house armed with a bow and arrow and shot the arrow which pierced on the chest of the deceased, Dhanu Maji, who sustained grievous injury and succumbed. Okay. Then
he's in custody.
Yes.
Custody, my lord, since
Right,
but
true?
right now, my lord, as I am unable to contact with him and the legal aid not able to provide me
the person who is responsible now upon the after shooting and so on, the appellant belongs to so and so. So, taking into account the ratio let down wherein this was the intention appellant to kill we are of the view that decision is applicable to facts and according to allow this appeal and so and so. Okay. So it is Jallu Maji versus State of Orissa. 2006 Supreme Court बाहर करो 3-2-4 तापर next AIR 2006 Supreme Court लिखिला page number होची 3240 हाँ मगा another decision is Asman Gond versus State of Orissa. Okay, what has happened here? The division bench of this court in Sami Adora. State reported in and considered the facts of the case wherein there was sudden quarrel between the wife of the deceased on the one hand and the appellant, and in course of which who accused had shot the arrows at the deceased and his wife, and the deceased had shot an arrow at the co-accused. On the spot of it is arrows man achi bode dekhiyo. Without any premeditation being incensed, the appellant belonging to Aboriginal tribe dealt a blow which landed on the swan, so who survived for some time and succumbed to the injury. আচ্ছা এইটা দেখিবা 98 আবার কোন 19 পাটিনা হলা সোনিয়া ডোরা হলা versus state reported in 1984 one Wheeler page হচ্ছে 665 the appellant number one of the author of this order anger to assaulted এটা fist and click both but এই যে dissent আর for এইজি এটা হচ্ছে আর ওজরা okay let us see that dissent then results picked up a call আরো assert আছে সানিয়া আন্তর এই যেটা রিলাই করছে তো সানিয়া আন্তরলে কোন হলা in that respect prosecution case is that so and so and the deceased borrowed some rice on so and so accused wanted to return the rice PW3 pleaded incapable to return accused become annoyed and picked up quarrel with PW3 deceased came to the rescue of his brother and intervened separated them the above conduct of the deceased resulted in a quarrel between the accused and the deceased thereafter the accused collecting a bow and arrow from the nearby house shot an arrow which pierced on the chest of the deceased, sustaining severe injury. The deceased fell down. Okay. Then what is the analysis and counsel for the short long term? Okay. Okay. Yes, for this we record the conviction 304 in place of so and so. देखिए edition ना पूरा सोनिया दासो थोड़ा सोनिया डोरा देखिए 12 GB पटना. It is not disputed at the bar that appellant's act had resulted in the death of the deceased. Mr. Raut has submitted on behalf of the appellant that the appellant had right of private defense of the person who accused Sania Dera at whom the deceased had served an arrow. The appellant had not pleaded the right of private defense in his statement before the trial court. Such a plea can, however, be sustained if it is played out from the prosecution evidence. As has been submitted by Mr. Roth for the state, there are no material to indicate that at the time of fatal assault was made by the appellant on the deceased, the appellant have reasonable apprehension in the mind that the death or grievous hurt the co-accused or such harm be caused to him. Owing to the attack on the decision, he therefore negates the right of private defense to disbelief. Then set up torn down Palapare. Mr. Raut contended that on the evidence on record, the appellant could be convicted under the second part of the section of penal code, although the medical evidence would show that the injury was sufficient in ordinary course of nature to cause death. Mr. Roth had fairly submitted that this contention is sound and we are of the view that this is acceptable. There had been sudden quarrel between the wife of the deceased on the one hand and the appellant on the other hand, in the course of which accused had shot the arrows at the deceased and his wife, and the deceased had shot an arrow at the co-accused Sania Dora. On the spur of the moment, without premeditation and being incensed by anger, the appellant belonged to Aboriginal tribe dealt, but one blow was landed and the head of the deceased who survived for some then succumbed to it. It would appear to us that the appellant had knowledge that by his act he was likely to cause the death of the deceased, but he had no intention to cause the death of so and so. The order of conviction on the so and so cannot be sustained is liable to ନେଇ ଆସିଲେ ତାକୁ 304 ତ ଆରୋଜ ମାରିଥିଲା ପ୍ରଥମରେ deceased କୁ ତାପରେ ପୁଣି ଆଉ ଗୋଟେ
sudden and immediate provocation.
ଏଠି ଏଇଟା କ୍ୱାରଲ ରହୁଛି କ୍ୱାରଲ ପାର୍ଟ ରହୁଛି ଆଉ ତ ଜେରା କରୁନାହାନ୍ତି and some kind of you cannot say that ସବୁ ଛାଡ଼ିଦବା ଆର ସେଇ 304 पर private short and arrow चार बईटा देलो से जो हाँ अच्छा
It a trial court is relied upon 2004-7 OCR. Sunil Kumar state.
sole testimony से दो that is not on the point देखो
We are not
हाँ
click on that.
पेपर बुकटा काढो कौन बात है आर्टिकल के विषय को रिलाय करें ওই যে পিরিয়ড কেতে যাইছি দেখি পিরিয়ড সে যাইনি মানে বাহার নি জমা কেবেটু রইলানি
Undergone 1992.
Custody manner. 1999. No, I am not able to even contact with any of 24 years.
What about the PW5?
PW5, let us see. PW5.
कुछ देखी जी PW5.
Yes.
PW5 was stated na the accused came to this one so quarrel with
As to why he was quarreling.
Shukra challenge as to why he was quarreling. I have no further committed his murder. It's not if I did not see the occurrence once. He has been named in the FIR as an eyewitness to the occurrence.
My lord.
This PW5.
My lord. ଉକ୍ତ ଘଟଣା ଶୁକ୍ରା ଶିଶା ହାଡି ଶିଶା
yes ଖାଲି ସେ ଇଏ କରିହବ ଅଲ୍ଟର କରିହବ ପ୍ରାକ୍ଟିକାଲ କରିହବ ଜେରା ତ ନାହିଁ ଆଉ ଟୋଟାଲ କଣ କରିବ ସେ ଇଏଟା ଦେଖି
ଆପଣ କିଛି କହିବେ
କଣ କହିବେ ମିଷ୍ଟର ତ୍ରିପାଠୀ ସେ ବ୍ୟାକଗ୍ରାଉଣ୍ଡ ଟାକୁ ପଳେଇ ଯାଆନ୍ତୁ ବ୍ୟାକଗ୍ରାଉଣ୍ଡ ପରେ ସେ ଘଟଣା ଦିନ ଯାହା ଏଫଆଇଆର ରୁ ଜଣା ପଡୁଛି ଅବଶ୍ୟ ସେଗୁଡା ସବୁ କିଛି ଆଣି ନାହାନ୍ତି ତାକୁ ପଚାରିବା କଥା ସିଏ ଆସିଛି ଆକ୍ଚୁଆଲି ସେ ଯୋଉ ଗାଈ ପଳେଇ ଆସିଲେ ତା ପୂର୍ବରୁ ଦେଖନ୍ତୁ କଣ ବ୍ୟାକଗ୍ରାଉଣ୍ଡ ଆସିଲା ଯେ ଇଏ ଲୋକଟି ଯିଏ ଆପେଲାଣ୍ଟ ସିଏ ହଉଛି ସେ ଯୋଉ ପୁଅ ଯାହା ସାଙ୍ଗରେ ସେ ଝିଅଟି ଲକ୍ଷ୍ମୀ ଚାଲାଣ ସେଇ ଝିଅଟି ଭଲ ଭାବରେ this accused is related to Lakshmi Chalan, right? Now
that is not there. Not there.
Not
how,
there.
How is related to Lakshmi Chalan is not there.
किए
This accused person. Petitioner.
अरे इट पर सुनो देखी चिंता पर आउथरे पडुना आदि एटी तुला ग्रामर संध्या चालाणर पुओ
लक्ष्मी चालाणर सान बापा हाडी चालाण
हां
तना पहला ना
सुनंतु लक्ष्मी चालाण गोटे पिला को बाहा ହେଇଥିଲା ହେଲା से जो झियो गोटे झियो से बाहा ହେଇଥିଲା जाको बाहा ହେଇଥିଲା ता ना होची सुक्री शिष्या ऑलराइट वी आर नॉट कंसर्न से लक्ष्मी चालाण कौन कला ना से जो झियो को जो भलो भाबरे न देखिबा जोगु से झियो कौन कला ना आउ गोटे पिला संगे पळेला राइट तेणु एग्रीड तापरे से झियोर उक्त झियो सर्वदा पई लोक मान को गुडा जे सेई झियोर मा पाकु आशा पळेला तापरे झियोर मा पाकु पांचटा गाई नै चल जाइथिले से गाई गुडा किंतु पुणी फेरी आसले का पाकु ना झियोर मा पाकु राग हैला सेठी हैला जे गाई गुडा फेरी आसले तेणु लक्ष्मी चालाणर सान बापा हाडी चालाण अर्थात से पुअर जो सान बापा हैला जी जा पाखकु झियो जाइथिला बाहा ହେଇଥିଲା किंतु से झियो पळेला तारी सान बापा होची आपलांट हाडी चालाण हाँ सान बापा माने ओके सान बापा दादा सी कौन हैला ना आसिला धनुतीर धरी गाँ रे जेमती आसी ये सब लुचि गले उक्त समय रे मोर सान बापा शुक्रा शिष्या अर्थात दी डिसीज ता घर पिंढारे बसतला ତା ଉପରକୁ ସୁଆଂଶ ବିନ୍ଧି ଦେଲା କିନ୍ତୁ ଏଠି ଏଭିଡେନ୍ସ
quarrel farrel କିଛି ନାହିଁ
ସେଠି ନାହିଁ କିନ୍ତୁ ବଟ୍
but the PW5
PW5 ରେ ଆସିଛି ଯେ କ୍ୱାର୍ଲ ଅଛି ଆସିଲା ପରେ କ୍ୱାର୍ଲ ହେଲା ପରେ ହିଁ ଯୋଉ ତୀର ମରା ହେଇଛି ହେଲା ଆଉ ଡିସ୍କ୍ରିପାନ୍ସି ହଉଛି କଣ ଗୋଟିଏ ତୀର ମରା ହେଇଛି ହଉଛି ଆପଣଙ୍କର ଏଭିଡେନ୍ସ କିନ୍ତୁ whereas ଦିଟା ତୀର ଦିଆ ହେଇଛି
disease ଆଉ ସେ ଝିଅର ରିଲେସନ କଣ disease ଆଉ ଝିଅର ରିଲେସନ
ମୋର ସାନ ବାପା
ଡିସିଜ୍ଡ
ତାହେଲେ ୟଙ୍ଗର ଫାଦର
younger father
ହଁ ଝିଅର ଇଏ ପୁରା ସାନ ବାପା ହବ ସେ ଯୋଉ ଝିଅଟା ଯୋଉ ଝିଅଟା ବାହା ହେଇଥିଲା ହଁ
ନାଇଁ ଯୋଉ ଇନଫର୍ମାଣ୍ଟ ଇଜ ଦ ଉକ୍ତ ସମୟରେ ମୋର ସାନ ବାପା ଶୁକ୍ରଶିଷା ତା ଘର ପିଣ୍ଡାରେ ବସିଥିଲା ଇନଫର୍ମାଣ୍ଟ ର ସାନ ବାପା ହେଲା ଡିସିଜ
ଆପଣଙ୍କର ଦେଖନ୍ତୁ ଇଏ ହଉଛି ଏଇ ଯୋଉ ଡିସିଜ୍ଡ ହଉଛି ଇନଫର୍ମାଣ୍ଟ ର ସାନ ବାପା ରାଇଟ ତେଣୁ ଇନଫର୍ମାଣ୍ଟ କହିବା କଥା ଏଇ ଯୋଉ ତାର ଇଏ ଅନୁଯାୟୀ ଫାଷ୍ଟ ହଉଛି ଗୋଟେ ପର୍ଟିକୁଲାର ଗୋଟେ ଝିଅ ଗୋଟେ ପୁଅଟାକୁ ବାହା ହେଇଥିଲା ସେଇ ଯୋଉ ପୁଅକୁ ବାହା ହେଇଥିଲା ଆକ୍ୟୁଜଡ ହଉଛି ତାର ରିଲେସନ ରାଇଟ ରିଲେସନ ମାନେ ତାର ସାନ ବାପା ହେଲା ସେ ଝିଅଟି ଯେହେତୁ ଆଉ ଗୋଟେ ସାଙ୍ଗରେ ଜଣକ ସାଙ୍ଗରେ ପଳେଇଲା ଗ୍ରିଭାନ୍ସ ଆସିଲା ସେଇଠୁ ସିଏ ଆସିକିନି ଝିଅର ମାଠୁ 5ଟା ଗୋରୁ ନେଇଗଲେ ସେ ଗୋରୁ ଗୁଡାକ ପୁଣି ଫେରି ଆସିଲେ ଘଟଣା ହଉଛି ତା ପରଠୁ ଆରମ୍ଭ ହେଇଛି ଯେ ଇଏ ଆସିଛି କାହାକୁ ନା ଆଙ୍କ ଗାଁକୁ ଆସିଛି ମାନେ ଗାଈ ନବାକୁ ଆସିଥିବି କଣ ପାଇଁ ତ ସେଇ ସମୟରେ PW5 ର ଏଭିଡେନ୍ସ ଯାହା ଦେଖଉଛି ଗୋଟେ କଜିଆ ହେଇଛି ବା କଳି ହେଇଛି କାହା ଭିତରେ ନା ଡିସିଜ ଯିଏ ବସିଥିଲା ସେ ପିଣ୍ଡାରେ ଏବଂ ୟା ସାଙ୍ଗରେ ଆସିଛି ହେଲା ତେଣୁ ସେଇ ଅବସ୍ଥାରେ ତୀର ମରା ହେଇଛି so during he had no intention to kill this person maybe that during course of that quarrel hala
he never came to kill this man
right and this use of ei jo dhanu tira eguda hochi tankara tribal community re eguda ko gote it's not an unusual feature ହେଲା ସେମାନେ ସବୁବେଳେ ସେଗୁଡାକ ଧରିକିନି ବୁଲନ୍ତି ମାଲକାନଗିରି ଜିଲ୍ଲା ହେଲା ତେଣୁ ଇଟ୍ସ ନଟ୍ ଆନ୍ ଅନୟୁଜୁଆଲ ବା ସିଏ ତୀର ଧରିଥିଲା ବୋଲି ଧନୁ ତୀର ଆପଣ କହିବେନି ଯେ ସିଏ ପ୍ରିପେୟାର୍ଡ ହେଇ ଆସିଥିଲା
right they are the rustic villages they generally carry this kind of bow and arrow and all
these are the things so and more important thing is that final form ଦେଖଉଛି ଯେ ଇଏ କଷ୍ଟଡି କି ଗଲା 9/6/19 so 9/6/19 ପରେ ट्रायल कोर्ट रेकर्ड देखौनी जे ये केतेबेले हेले बेल रे थिला बेली कारण हाँ सबु बेले देखौची अक्यूज्ड प्रोड्यूस्ड इन कस्टडी इवन इफ डेट ऑफ जजमेंट पर्यंत से देखौची अक्यूज्ड वाज प्रोड्यूस्ड इन कस्टडी हाँ तेणु से ये जो जजमेंट टा हला 3/8/2006 ହେଲା ତା ମାନେ ଦେଖନ୍ତୁ 2006 ମାନେ ସେତେବେଳେ ପର୍ଯ୍ୟନ୍ତ ସିଏ ଅଲରେଡି ରହିଯାଇଥିଲା କେତେ ନା 7 ଇୟର୍ସ ରହିଯାଇଥିଲା ତାପରେ ଆପଣ ଯଦି ହାଇକୋର୍ଟ ଅର୍ଡର ସିଟ୍ କୁ ଆସିବେ ହାଇକୋର୍ଟ ଅର୍ଡର ସିଟ୍ କୁ ଆସିଲେ ପେପର ବୁକ୍ ନେ ଅର୍ଡର ସିଟ୍ ହାଇକୋର୍ଟ ହଁ ତାକୁ ବେଲ ମିଳିନି ହେଲା ଆକ୍ୟୁଜ ନେ ପଡଲା ହାଇକୋର୍ଟ ଅର୍ଡର ସିଟ୍ କାଇଁ
6/2/2008
दिस अपील डिले कौन नहीं गला टोटल ये देखिए थोड़ा हाई कोर्ट ऑर्डर सीट है तापाई केही केबे बेल भी मूव करना एटा होची एडमिट हे गला अपील 6/2/2008 रे तापर आ एटी उडा कोनला 4/7/2003 न पेपर बुक ये माने एंगेज करा गला बस सती तो ही इज इन मिस्टर त्रिपाठी 1999 मसीहारू तामाने केते वर्ष हला कहले
near about 24 years
24 years this man is in custody देखो हार्ट JCRL number 100 of 2006 देखो हाँ
2000 हाँ ये
चार स्टेप वाला the appellant faced trial in the court of learned additional session judge Malkangiri in sessions case number 3 of 2000 for offense punishable under section 302 of the Indian Penal Code on the accusation that on 29/5/1999 at about 3 p.m. at village Goi Guda, he committed murder of Sukra Sisa bracketary hereafter the deceased. The London Trial Court by judgment and order dated 3rd August 2006 found the appellant guilty of the offence charged and sentenced him to undergo imprisonment for life and to pay a fine of rupees 5,000 in default to undergo further RI for 6 months. The prosecution case, as per the first information report lodged by Lakshmi Sisa bracketary PW4 on 29/5/1999 before the officer in charge of Mudulipada police station is that three years prior to the lodging of FIR, one Lakshmi Chalan of village Tula Guruma had married to one Sukri Sisa, who was a co-villager of the informant. After marriage, the girl Sukri Sisa eloped with another boy. For which the co-villagers of this husband of that girl namely Lakshmi Chalan, came to the village of the informant and took away 5 cows from the mother of the girl. However, the cows returned to the village of the informant on their own. At this, on 29/5/1999, the appellant Adi Dhangada Maji alias Chalan, who was the paternal uncle of Lakshmi Chalan, came to the village of the informant at about 3 p.m. holding bow and arrows. Seeing him, the villagers of the informant concealed themselves. The deceased Sukra Sisa was sitting on the veranda of his house and he was the uh, paternal uncle of the informant. The appellant saw two arrows at the deceased and one arrow hit on the chest of the deceased and the other arrow hit on the right side abdomen. Of the deceased, for which he fell down on the ground. The appellant left the spot carrying the bow and arrows. It is stated that Shukra Sisa bracket PW5 Hadi Sisa examine ହେଇଛି
No, no, man.
comma one Hadi Sisa and others had seen the occurrence. After the appellant left the spot, comma, the villagers came near the deceased and found that he was lying there on the ground, being shot with two arrows, one on the chest and the other on the abdomen region, lying dead. The informant broke the wooden portion of the arrows The villagers wanted to report the matter in the police station, but at that point of time, the appellant again came to the spot and threatened the villagers that if anyone would touch the dead body of the deceased, comma, he would also be shot with arrows. Stop. Due to such threat, the informant and others could not bring the dead body to the police station, and written report and report was lost indicating therein that the dead body was lying in the village. On the basis of the oral report given by PW4 Lakshmi Sisa, PW7 Sarbeswar Naik, the officer in charge of Mudulipada police station, registered Mudulipada PS case number 21 dated 29/5/1999 under section 302 of the Indian Penal Code against the appellant. And he himself took off investigation of the case. Stop. During course of investigation, he examined the witnesses, visited the spot, seized 2 numbers of arrows as per seizure list exhibit 3, held inquest over the dead body as per inquest report exhibit 4, sent the dead body to medical officer CHC Khairaput for post-mortem. He seized the bloodstain earth and sample earth from the spot as per seizure list exhibit 5. He also seized 2 arrows and wearing apparels of the deceased as per seizure list exhibit 2. On 4/6/1999, PW7 arrested the appellant, seized 1 bamboo bow as per seizure list exhibit 6, and the appellant was forwarded to court on 5/6/1999. The postmortem was conducted. Postmortem টা কোর্টে এসে দেখিলে যে পোস্টমর্টম পিএম রিপোর্টটা যেটা বাহার করেছিলেন
Exhibit 7.
हॉस्पिटल ରହିଛି ଆଉ ଟିକେ ଏଇଟା ଟିକେ Khairput. In the CHC, Khairput, and the doctor conducting postmortem examination noticed 2 arrows struck to the body of the deceased, one on the right side chest and the other on the right side abdominal cavity. And he opined the cause of death to be hemorrhage and hypovolemics due to arrow shot, and the report was marked as Exhibit 7. সেটা পড়ে আসো সেই যে এভিডেন্সটা দেখছিল। The postmortem report was received. The postmortem report bracket like Exhibit 7 was received by the IO bracket PW7 on 7/7/1999, who also made a query to the doctor about possibility of the injury on the deceased by such arrows, and the doctor gave his report by Exhibit 8/1 and opined that the injuries were possible by the arrows. On 28/1999, the IO bracket PW7 sent the exhibits to RFSL Berhampur for chemical examination, and on completion of investigation, he submitted charge sheet under section 302 of the Indian Penal Code against the appellant. Next para, the case was committed to the Court of Session after observing due formalities where the London Trial Court framed charge on 15/11/2001 under section 302 IPC against the appellant, and since the appellant pleaded not guilty and claimed to be tried, the sessions trial procedure was resorted to prove his guilt. Stop. Next para. In order to prove its case, the prosecution examined 7 witnesses, named those witnesses, and in short what they have stated. The defense plea of the appellant is one of denial, and he stated that on suspicion he has been falsely implicated in the case. The London Trial Court, next para, after analyzing the oral as well as documentary evidence on record, has been pleased to hold that the death of the deceased due to RO shot is admitted, and the statement of PW5 is truthful, cogent, credible, and trustworthy, and enough for securing conviction. And accordingly, the appellant was found guilty under section 302 of the Indian Penal Code. The Land Counsel for the appellant, so and so, has been engaged by the High Court legal aid so and so, submitted that except the evidence of PW5, who claimed himself as an eyewitness to the occurrence, there is no other material against the appellant, and to corroborate the evidence of PW5. The Land Counsel further argued that even though in the first information report, PW4 S.S.MISHRA has mentioned that apart from PW5, one Hari Sisa and others had also seen the occurrence, but none of them have been examined to corroborate the evidence of PW5. The London Council further submits that PW5 has stated that the appellant shot an arrow at the deceased and committed his murder, whereas in the post-mortem report, the doctor has noticed 2 arrows struck to the body of the deceased, one at the chest and the other at the abdomen region, and therefore there are discrepancies in the oral evidence of eyewitness and eyewitness bracket PW5 and the medical evidence. The Learned Counsel further argued that the doctor who conducted postmortem examination has not been examined during trial, and the postmortem report has been proved by none else than PW7, and therefore by non-examining a material witness like the doctor who conducted postmortem examination, the defense, the appellant has been seriously prejudiced, as many more things could have been elicited from the evidence of the doctor. The Learned Counsel further argued that is it a state defense counsel during trial?
No,
Let us come to the judgment.
Badal Banjing and
Public Badal Panigrahi wants to advocate. କେମିତି କି engage କଲେ ଏଟା ନିଜେ ବୋଧେ engage କରିଛନ୍ତି ଏଟା ଦେଖିଲେ ତଳ କୋର୍ଟର ରେକର୍ଡଟା ବାହାର କଲେ ଅର୍ଡର ସିଟ୍ ପ୍ରଥମ ହେଲା ଚାର୍ଜ 100 ରେଜିଷ୍ଟର କଲା receive the records 100 ଏଇ ଇଏଟା ଦିଅ ତାର वकालत ନାମାଟା କର वकालत ନାମାଟା ଦେଖିଲ ହବ वकालत नामा फाइल ହେଇଛି 20 ତାରିଖରେ ଫାଇଲ ହେଇଛି 2002 ମସିହାରେ ହଁ ନଭେମ୍ବରରେ 20 ନଭେମ୍ବର 2002 ରେ ଆଚ୍ଛା ଦେଖିଦବା ଅର୍ଡର ସିଟ୍ 20 ନଭେମ୍ବର 2002 ये नवंबर अच्छा 20 नंबर 2002 अच्छा किए दाम था पूर्व तो जेरा आरंभ ହେଇଥିଲା accused produced in so and so ସେ वकालत नामाଟା ଟିକେ ଦେଖି ଆଉ ଥରେ ଦିଅ ତଳ କୋର୍ଟ ରେକର୍ଡ ଆସିନି କି ଫେରି ଦଉଛନ୍ତି ସବୁ ଗୁଡାକ ରେକର୍ଡ ମଗେଇବ ହେଲା ଯୋଉ ଆସୁଛି ଯୋଉ ଜେରକ୍ସ ହେଇନା ଆସୁଛି ଓରିଜିନାଲ ଆସୁନି ହେଲା ଜେରକ୍ସ ଆସିବ ପ୍ଲସ୍ ପେନ୍ ଡ୍ରାଇଭ୍ ଆସିବ ଯେତିକ ନାହିଁ ସବୁ ମଗେଇ ଦିଅ କାଲି ଭିତରେ ଆସି ସବୁ ପହଞ୍ଚିବ এইটা ଏ वकालत ନାମରୁ ଦେଖା ହଉଛି ଏଇ ଯୋଉ କାଉନସିଲଙ୍କ ନାଁ ଲେଖା ହେଇଛି 11/4/2003
हाँ, like accused is present in the custody. He prays to engage and engage side from him.
नहीं
As
स्टेट
he
डिफेंस
has
काउंसिल
no
फॉर हिम
means
SDC
to engage.
for him as he has no means to engage so and so
And
accordingly D परीक्षा
the Panikre,
परीक्षा
Paricha
is
is
engaged
appointed as a
আচ্ছা সেটা হচ্ছে দেখিয়ে দেওয়া এটা হচ্ছে 11/4/2000
11/4/2000
11/4/2000 କିଏ ନା ଆଡଭୋକେଟ ନା କଣ
D Paricha.
ଟି ପରୀକ୍ଷା ତାପରେ କଣ ହେଲା ସେ ଏନଗେଜ କରିବା
Engage
କେମିକାଲ 11/4/2000 ଦେଖିବା
is
11/4/2000 ତାପରେ produced accused is produced gala then record is put up today as C report as received যেটা হচ্ছে 1/11/2000 তারপরে C report has been received কলা ଚାର୍ଜ ଫ୍ରେମ୍ ହେଲା ସେଇ ଇଏ ଥିଲା 15/11/2001 ଚାର୍ଜ ଫ୍ରେମ୍ ହେଇଛି accordingly charged 15/11/2001 charge framed. Then ସାକ୍ଷୀ ଆରମ୍ଭ ହେଇଗଲେ ସେଇ ଲର୍ଣ୍ଣେନ୍ ଏବଂ 28/6/2002 ଅର୍ଡର ସିଟ୍ ଦେଖଉଛି ଲର୍ଣ୍ଣେନ୍ ଷ୍ଟେଟ୍ ଡିଫେନ୍ସ କାଉନସିଲ ଆଣ୍ଡ ପିପିଆର ପ୍ରେଜେଣ୍ଟ ତାହେଲେ ଷ୍ଟେଟ୍ ଡିଫେନ୍ସ କାଉନସିଲରେ କେସ୍ ଚଲେଇଛି ହଁ ଷ୍ଟେଟ୍ ଡିଫେନ୍ସ କାଉନସିଲ ହଁ ଚଲେଇଲା ତାପରେ ନେକ୍ସଟ ଇୟର ଆସିଲା ପିଓ ଲିଭ୍ ଗଲା 17/8/2022 नो PWs ଗଲା 19/8 21/9 नो PW then 23/9 counsel for both the side present hearing the case the producer hearing of this one ଏଇଠି ସେ ଏନଗେଜ କଲା 20/11/2002 ନିଜ କାଉନସିଲ ଏନଗେଜ କଲା ऑर्डर नंबर 29 तापरटा देखो जस्ट हां ସେଇଠି ଲେଟର ଲାଇନ ସେ ଯୋଉ ହଁ ହଁ ସେଇ वकालतनामाଟା ମଧ୍ୟ ଯୋଉ ଆମେ ଦେଖୁଥିଲୁ ସେଇଟା ହଉଛି ସେ ବାଦଲ ପାଣିଗ୍ରାହୀର वकालतनामा
ବାଦଲ ପାଣିଗ୍ରାହୀ ଫ୍ୟାମିଲି ଏପିଏ
ହଁ ତା ନାଁଟା ଜଜମେଣ୍ଟ ଆସୁଛି ନା ତ ସେଇଠୁ ସେ ତାମାନେ ସେତେବେଳକୁ ସେ ଯେତେବେଳେ ଆପିୟର କଲା ସେତେବେଳକୁ PW5 ର କ୍ରସ୍ ଏକ୍ସାମିନେସନ କେବେ ଏଇ ଯୋଉ ଇଏ ଏକ୍ସାମିନେସନ କେବେ ହେଇଥିଲା କ୍ରୁସିସା 19/7 अच्छा 19/7/2005 रे अरे इज इट राइट 19/7/2005 ना 2000 हाँ 19/7/2005 5 ମାନେ ସେତେବେଳକୁ ଆପଣ ନିଜ କାଉନସିଲ ଏନଗେଜ ହେଇଯାଇଥିଲେ 19/7/2005 ରାଇଟ କାଉନସିଲ ରାଇଟ କଣ ଲେଖିଥିଲେ ପଢିଲେ the material witness like PW5 has not been properly cross-examined, which has caused serious prejudice to the appellant. It is further argued that the evidence of the eyewitness PW5 would indicate that the appellant picked up quarrel with Sukrasisa mane kiye deceased pura with the deceased and when the deceased challenged as to why he was quarreling the appellant sought an arrow at him. It is submitted that the appellant belonged to tribal community and holding of bow and arrows is not unusual on their part.
Rustic villages of the tribal area carrying bow and arrow is an usual thing.
It'll like the main part like that. And Therefore, if during sudden quarrel he shot the arrows, the offense would not come under the section 302 IPC, and it may be an offense under section 304 part 2 of the Indian part 2 na part 1 কোটা কোন করছেন আমার ডিসিশন আছে part 2 এটা কোন করছেন part 1 করব part 1 of the Indian penal code এথরে বন্ড আরো কেসটা দাও so shooting arrows করবা the accused ratio A5 shot an arrow which hit so and so on the back, and the accused shot an arrow which so and so which fell on down, the accused run away. ঠিক আছে it would be case under section 304 part 1 of the Indian Penal Code. The learned counsel for the state, on the other hand, supported the impugned judgment and submitted that you find out that the exhibit list that the postmortem report exhibit 7 was marked without objection on 25/7/2006 when the IO bracket ray it did without objection to লেখা exhibit list যেটা আছে the list of exhibits এটা হচ্ছে exhibit 7 PM report without objection date হচ্ছে 25/7/2006 and in the when PW7 proved the same acha final form re doctor witness thila na nai PM doctor
চার্জশিট দিলে
চার্জশিট এটা হচ্ছে চার্জশিট ডক্টর হ্যাঁ ডক্টর ଥିଲେ না না এটা হচ্ছে কোন সংজ্ঞা বেহেরানা PM প্রাইট লেখা হয়েছে PM so let us see that order sheet କାହିଁକି ସବୁ examine କଲେନି ସେ PW IO date କେବେ examine ହେଇଛି PW7 ଟା
25/7/2006
25/7/2006
25/7/2006 order sheet ଟା বার করো trial court
সাত 2006 না
check
25/7/2006 today the case record was posted for evidence by IO directly that to last data
picture 25/7
and
আর দুই
only stage limited to conduct investigation and then
এটা দাও IO 25/7/2006 accused is produced so and so IO was directed last in so and so and then under the version special be access is now to conduct the was son okay neither the land relying on so and so take all the evidence for the prosecution for however relying on the so and so speedy trial okay and called upon to enter okay recorded separately and so the IO's evidence was recorded on that day So there is nothing as to why the doctor was not examined. Suppose he is dead, matter would have been different. All right. ହେଲା କଣ ଲେଖିଲେ? Okay. The evidence of the সেটা বাহার করা সেই PW5 ର the evidence of the eyewitness bracket PW5 has almost remained unchallenged, and when 2 arrows were shot at the deceased, which hit on the vital part of the body like chest and abdomen, and the postmortem report indicates postmortem report bar karo exhibit list of exhibits 7 ନା କେତେ ଗୁଡା ହଁ postmortem report corroborates that the death of the deceased took place on account of arrow shots, and the cause of death was hemorrhage and hypovolemic shock on account of arrow shot. The learned trial court has rightly convicted the appellant under section 302 of the Indian Penal Code, and the appeal should be dismissed. Stop. It appears from the trial court record that the petitioner was taken into judicial custody on 9/6/1999, and trial court judgment was pronounced on 3/8/2006, and he was never released on bail. During pendency of the trial. During pendency of the appeal also, he was never released on bail. As such, he has already undergone sentence of more than 24 years. जो रिपोर्ट आसला देखिले जो लास्ट ऑर्डर अनुଯାୟୀ हाँ ऑडियो A report has been received from the report report has been received Senior Superintendent Circle Jail Koraput bracket Welfare Service dated 12/7/2023, wherein it is indicated that the appellant was transferred from Circle Jail Koraput to Biju Patnaik Open Air Ashram, Jammu Jhari on 25/2/2010 for confinement. ଇଏ ପଳେଇ ଆସିବ ଏଭିଡେନ୍ସ କୋଉଠି ଯୋଉଟା ଅଛି। ହଁ। On careful analysis of the evidence on record, it appears that PW1 accompanied the dead body for postmortem examination, and after the postmortem was conducted, he received the wearing apparels of the deceased along with the weapon of offense which was pierced in the dead body from the doctor, and produced the same before the IO which was seized under seizure list exhibit 2. And PW2 is also a witness to the seizure of the said seizure list exhibit 2. So also PW3. PW4 is the informant in the case, but he has stated that he has not seen the occurrence, but hearing about the same, he orally reported the matter at Mudulipada police station. And in the cross-examination, he has stated that the written report was not read over or explained to him. PW6 didn't say anything about the case, and PW7 is the investigating officer. Therefore, the entire case of the prosecution rests on the testimony of PW5, who claims himself to be an eyewitness to the occurrence. Law is well settled, Sapparagalam, that in order to base a conviction on the evidence of a solitary witness, the same must be clear, cogent, trustworthy, and reliable. And we have to examine the evidence of PW5, keeping the principle in view. Stop. PW5 was examined in court in the trial court on 19/7/2005, and he has stated that the occurrence took place about 5 years back, and the appellant came to their village and picked up quarrel with the deceased, and when the deceased challenged as to why he was quarreling, the appellant shot an arrow at him and committed the murder. In the cross-examination, he has denied the suggestion of the learned defense counsel that he did not see the occurrence and that he was absent from the village. And further denied the suggestion given by the defense counsel that since he was in inimical tone with the appellant, he has deposed falsehood. Stop. The examination in chief of the eyewitness has remained on second, unchallenged, and practically no cross-examination has been made to disbelieve the evidence of PW5, except putting some questions, except giving some suggestion to him. We verified from the case record that though earlier the State Defense Counsel was engaged to conduct the case for the appellant, but after the charge was framed on 15/11/2001, the appellant engaged his own counsel on 20/11/2002. 2002 না 20/11/2002 টিকে দেখতে হবে এই যে অর্ডার শিটটা দেখতে হলো এলসিআর অর্ডার শিটটা 20/11/2002 টিকে দেখিলে পরটা ল্যাপটপের সাইজ ঠিক তো and PW5 was examined and cross-examined on 19/7/2005. Therefore, when the vital witness of the prosecution, that is PW5, was examined, the appellant was represented by his own counsel, and if his own engaged counsel did not put any question to discredit the evidence of a vital witness like PW5, no blame can be put on anybody. Stop. Para. The PW5 no doubt has stated that the appellant sought one RO at the deceased, and the doctor and the postmortem report indicates that in fact 2 ROs were struck on the body of the deceased, one on the right side chest portion and the other on the abdomen portion. However, this discrepancy itself is not a ground to to disbelieve the prosecution case in toto, and it cannot be said that the appellant is no way responsible for the death of the deceased. Stop. At this stage, if we look into the background of the case and the status of the appellant, it appears that he belonged to he belonged to a tribal community, and rustic villagers of tribal area carrying bow and arrows is an usual and day-to-day affair, and they carry this kind of weapons as an accessory, adding to their attire as they generally go for hunting. Stop. Therefore, merely because the appellant came to the village of the deceased on the relevant day with a bow and arrow, it cannot be said that he had come prepared to kill the deceased. In fact, there is no material on record that there was any kind of previous enmity between the appellant and the deceased. And further, it appears that on the fateful day, there was sudden quarrel between the appellant and the deceased. And when the deceased challenged the appellant as to why he was quarreling with him, the appellant shot the arrow at the deceased. The Honorable Supreme Court, in case of Lakshman versus State of MP, reported in AR 2000 Supreme Court 3240, in which the accused also shot the arrow at the deceased, and the postmortem report of finding the good arrow shot case to the yes. Injured person was down from not to establish this answer and sentence will not. Okay, for your wife. So festival was going on. Okay. On the way, accused Lashman. Lashman is the appellant. Okay. So came to the field situated in the backside. Ran away to for the injured person and postmortem report with the so ran away from the villages that the accused persons have stopped the deceased and were assaulting him. On hearing this, the complainant so other persons of the village went running to the village. The accused started shooting arrows and pelting stones. Accused so and so hit appellant number 3 and arrow on the right shoulder of the complainant. Accused Lashman shot an arrow which hit at the deceased. আচ্ছা এটা arrow আছে. And on such sustaining injury is fell down. All right. On লিখলে কোন the as a result of which the deceased fell down on the ground and died instantaneously. The Honorable Supreme Court came to adjudicate whether the offense should come fall under murder or culpable homicide not amounting to murder. The Honorable Court held as follows. Quote from paragraph 10 वाचो 10 कर दियंतु 10 टा then 11 एटा छाड़ दियंतु अन्य केस गुड़ा साइड ହେଇଛି then 15 टा अन्य केस 17 टा 16 17 हां 12 टा
for the case 4 clause 3 that the offenders intend to
हां एटा भी कर दियंतु एटा करी कि नहीं to cause death ए पर्यंत करियो पूरा ना then you come to paragraph number 18 but you are on no decision ଅଛି 18 so sometimes facts 19 भी कर देगा 18 19
21
then 21 in the factual background when during course of quarrel when there was no previous enmity between the appellant and the deceased and there was no premeditation on the part of the appellant to commit the crime when the occurrence took place all on a sudden and during course of quarrel and the appellant was having bow and arrows with him shot arrows at the deceased in our humble view, the ratio laid down by the Honorable Supreme Court in case of Lakshman is applicable to this case. And in our view, the act of the appellant would come within the first part of section 304 of the Indian Penal Code. And accordingly, the appellant is convicted. The conviction is altered from section 302 TO2 304 part 1 of the Indian Penal Code. And we sentence the appellant to arrive for 10 years. And since the appellant has already undergone sentence of more than 24 years, he should be set at liberty forthwith if his detention is not required in any other case. A note of appreciation on the effort of Mr. Vikas Chandra Parija. यहाँ ना लिखा उल्लेख करिया दरकार नहीं मिसेस चंदना पंडा ना लिखिबेनी ओनली विकास चंद्र परिजा ना लिखिबे है ना एंड Yes, and Mr. Tripathi ko na likhe, note of appreciation de deba. And he has been engaged, so he will be paid to by the legal aid. ତାଙ୍କର ସେମାନଙ୍କର fixation ଆମେ engage କରିଥିଲେ, we would have paid. Okay. Yes, next case, Salda.